mobile phones, recorders, iPad, tablets, for the purpose of taking video, pictures, and recording the proceedings is prohibited. These devices must be switched off or at least put on silent mode, as this may disturb the proceedings. Only accredited members of the media could use laptops and other similar devices for the specific purpose of taking down notes. Otherwise, said devices could only be used outside the interview room. Please all rise for the Judicial and Bar Council members. Honorable Attorney Maria Milagros and Fernan Cayosa, Attorney Jose V. Mejia, Honorable Justice Aurora Santiago Lagman, Honorable Justice Regino C. Hermosissima Jr., Honorable Undersecretary Michael Frederick Musni, and Honorable Associate Justice Diosdado M. Peralta. Manatili po tayong nakatayo para sa panalangin, pag-awit ng lupang hinirang at ng Supreme Court Hymn. Sa ngalan ng Ama, ng Anak, ng Espiritu Santo. Amen. Maraming salamat, aming Panginoon, sa inyong paggabay sa amin sa maghapon, sa pagpili ng mga nominado na isusumiti sa aming Pangulo upang maging bagong punong mahistrado. Mga kagalingan, mga kabutihan, mga adhikain at konkretong plano ng mga kandidato sa maselang pwesto, dito hinihimay at niriripaso ng aming JBC, pati na ng publiko. Ngayong huling araw ng aming proseso, sana po'y pahintulutan na maging kumpleto ang tamang batayan ng aming JBC sa pag-shortlist nila ng mga nominado. At sana'y gabayan ang aming Pangulo sa kanyang pagpili ng punong maestrado upang mapalakas ang sangay ng gobyerno na nagpapatupad ng aming rule of law at ng katarungan para sa lahat ng tao. Amen.
Bayang magiliw, temas ng silanganan, alam ng puso, sa dibdib mo'y buhay. Lupang hinirang, duyan ka ng magiting, sa manlulupit, di ka pasisingil, sa dagat at bundok, sa simoy at sa langit kong baghang, may nilang ang tula at awit sa paglayang nilamahal, ang kislap ng
session is open.
Today, we continue the Judicial and Bar Council public interview on candidates for the position of Chief Justice of the Supreme Court. The candidates to be interviewed this morning are the following: Chairperson Teresita J. Herbosa, Securities and Exchange Commission, and Congressman Ronaldo B. Zamora, Senior Partner, Zamora Poblador Vasquez and Bretaña Law Offices. This afternoon, we shall be interviewing Associate Justice Honorable Maria Lourdes Punsalan Aranal Sereno of the Supreme Court and Associate Justice Presbitero J. Velasco Jr. of the Supreme Court. May we request Congressman Zamora to proceed to the holding area while the interview of Chairman Teresita J. Herbosa is being conducted. Thank you.
Good morning,
Good morning, Your Honors.
Good morning, Chairperson. Tony Cayosa, please.
If I may just say something for a very short time.
So yes, anything, ma'am?
Yes, I just want to say I'm very honored to be here, and I'd like to thank the person or persons who nominated me for giving me this opportunity to be considered for such an exalted position. And I wish to express my thanks to the staff of the JBC who assisted us very well in complying with the many, many requirements, and of course, the honorable members for allowing me to take part in this selection process. Thank you.
Okay. Tony Cayosa then.
Thank you, Mr. Chairman. Chairperson Herbosa, good morning. You were nominated and you accepted that nomination. Why did you decide to accept, and why do you want to become the next Chief Justice?
Having had 33 years experience as a private practitioner, particularly as a litigation lawyer, and also just even 1.5 years as chair of the SEC, I feel like I have all the qualifications, and these unusual times call for unusual solutions, and I believe that when it comes down to the bottom line, whether an outsider or insider, it doesn't really matter. It's more whether the person is equipped with the skills to be able to unite or lead the group to overcome the present crisis and go for a common goal.
You speak of a common goal. What is the common goal of the Herbosa Court?
To my mind, there are 3 things that I'd probably want to work for when I'm given the opportunity, and that is to give everyone access to the courts, and no one should suffer any delay, and that all decisions, in whatever form or manner, should be in the basis of merits, and the court itself should probably be able to give everyone fair and equal treatment.
Thank you, Madam Chairperson. Now, I noticed from the personal data sheet that you submitted that you have had 33 years in private practice and 1 year in government service. Could you tell me if this practice of yours was basically in Metro Manila?
No. I started out in Accra Law first in the corporate department, but when I saw all the male lawyers going to courts, I said, why can't someone like me go to court too? So I said I wanted the court cases, especially when I came back from my master's from Michigan. And so they gave me cases, and I don't know if it was by design that they gave me cases outside Metro Manila. And so I had to travel to Cagayan de Oro, Cebu, drive to Bataan, and I practically appeared in almost so many courts, appellate practice too. And while we did engage in commercial litigation, I was fortunate to have a variety of cases assigned to me, both civil, criminal, and administrative. So to me it was really an experience that's as varied as one could hope for as a litigation lawyer.
Now, you became a managing partner in 2004, and you held that position for the law firm until 2010. During the time that you were managing partner, were you still litigating?
Yes, Your Honor. In fact, if I may correct, I was a co-managing partner during that time. The managing partner was actually attorney Eusebio Tan. But I was in charge even then over so many things in the office, administratively, computerization, physical facilities, even non-legal, which I handled for some time. But during all this time, even if you do administrative work, as a partner, you're also supposed to lead the teams handling actual cases.
So continuously since the time that you joined the law firm, you have been consistently litigating and appearing in court as well?
Yes, Your Honor. In fact, if I remember correctly, one oral argument I had before the Supreme Court was, I think, after 2003.
Now, have you been involved in public interest groups and, pursued any advocacy?
Yes, Your Honor. In fact, I was lucky enough to take part in a UNICEF-funded project dealing with training police officers in the handling of child-sensitive cases. And we were 4 in the group, which included Attorney Katrina Legarda, Doctora Madrid, and Doctora Fortune. And we went around the country training police officers how to handle child-sensitive cases. And that has been my advocacy ever since. I am also legal consultant for the Child Protection Unit. And it is a joy for me to be able to impart to police officers the intricacies of criminal procedure. And in fact, it also taught me a lot about, of course, dealing with cases involving children. So it was a two-way street. After those lectures, we probably were able to lecture to about 2,000 police officers all over the country. I was also invited to lecture at the Police Academy. And then I also took part in the making of videotape materials for the FILJA, where unfortunately I was assigned the role of a prosecutor who didn't know how to appear in court or who didn't know how to handle child-sensitive cases. And I think these videotape materials are being shown to judges who are going to be judges of family courts.
Thank you, Madam Chairperson. Now, that being the case, having been exposed to child welfare, do you believe that restorative justice can be extended to just beyond, even to adult offenders and not just to minors? Because right now, the policy is really restorative justice for minors.
I've also handled a lot of, well, not a lot, I could count them, criminal cases as the official counsel. I recall that in my early years as a litigation lawyer, I was assigned to handle a case for 2 suspects who were accused of being part of an Akyat Bahay gang, and they had allegedly broken into the house of a celebrity and able to take away valuables. And I recall that during my interview with the suspects who were assigned to me as my clients, I sort of knew that they had probably some participation in the crime, but nevertheless I was able to have them acquitted on the ground that nobody could identify them. Now, that's really the job of a lawyer. Sometimes you really have to defend the client the best way you can, and this should be the rule, in fact. And there's another criminal case that I handled, and this was really a very sad one. The Supreme Court assigned me to handle a case of illegal recruitment where the woman, an old lady, was accused of not having a license and engaging in recruitment. And I was assigned only at the Supreme Court level already. And she was in the correctional, and I used to visit her there. And I thought that it was a very novel issue involved because she was, the fact that she had no license to engage in recruitment was established through a stipulation of fact during the case. And my position was, if such an admission would have to be made, especially during the pretrial of a criminal case, it would have to be signed by both counsel and accused. But unfortunately, the decision that came out, People versus Hernandez, which I think is cited in many other cases, is that it is a valid judicial admission, which of course resulted in the affirmation of the conviction. So I lost that case. Now, in those situations, you could see that whether it's out of poverty that the suspects committed the crime or charged with the crime, or it's somebody who maybe because of circumstances where she was the one who actually was charged and the one who was really guilty was not caught. I really think that there should be an opportunity for everyone to be able to rehabilitate and go back to society.
And I suppose that is a reason why you have made access to the courts one of your priorities. Now, let's get into specifics. How do you propose to make access to justice or enhance access to justice by the poor within the first 100 days of your incumbency?
Yes. Well, I think the other nominees have already pointed out the fact that we lack judges. I think it's about 30% that there are vacant positions in the judiciary. Maybe we have to fill that up. Maybe we should have more special courts to deal with special cases. And maybe the filing fees should be graduated according to the nature of the case. And there should be more meaning to litigating as an indigent. And some provisions of law will probably be utilized in order that there would be less delay and less congestion. Then, if that's the case, more could really access the courts.
As Chief Justice, you become the ex officio chairman of the JBC, and you are proposing that we fill up the courts in order to bring down the percentage of the number of vacancies. What specific action do you plan to take as JBC chairman?
Well, this process, I think, is very geared towards getting the best candidates for the position. I've been thinking about it, and I feel that being a judge should be something in most people may have been at the back of their minds even when they were law students, and therefore in law school they should make available courses that would train people to become judges. I think after finishing 4-year undergrad course, you must be during law school already prepared to identify which area of law you'd want to go, and if it's to be in the judiciary, then the training should start even there. But I guess when we look at applicants for the judiciary, it's not really just whether they could decide cases, whether they've had experience appearing before courts, but it's more also whether they can at some point terminate litigation earlier than should be, or than is the usual. If at the first point judges are trained to mediate or maybe to ask the right questions, so in order to expedite the proceedings.
Well, actually, the dilemma that faces the JBC is not so much the number of applicants. We have sufficient applicants. It's the distribution, because there are some areas where there are no applicants. Like we've had, I think, to publish the vacancies in Tawi-Tawi twice because there are no takers. What do you think is a good solution to that perennial problem?
I would only think of maybe budgeting and giving judges assigned to far-flung areas a little more in terms of hazard pay, and probably by way of rotation, if there will be people wanting to be promoted to higher positions in the judiciary, should probably be assigned to even those areas where they would really have a lot of challenges in dispensing justice. I've had many experience where I saw the poor conditions in the provinces. I remember a judge one time pointing to me where he was staying. It was a not so far away from the court, and he said that he just had one room, and he couldn't afford more than just or to bring his family to the place where he was assigned.
Thank you, Madam Chairman. We also have the Philippine Judicial Academy. Okay. What do you think should be the role now of the PhilJA, given the need for a better administration of justice? What would you do with, what would you plan for the PhilJA within the next 5 years?
If I were in PhilJA, and I've taken small participation in it, I think that judges themselves should be able to train other judges. I know that presently experts or maybe those who are known in their fields are asked to lecture to the judges, but in the end, the judges with their experience would probably be the best to know what the solution is to their problems. One other thing is probably there should be emphasis on little-known fields of law. I've noticed in my experience that not all judges know how to deal with estate cases, and these are really the very messy ones, and they also don't know how to handle heirs who are fighting each other, and of course, they probably have forgotten what they've taken up in succession regarding how to divide and distribute the estate. So there are those cases which I think should be also given importance. Of course, the one other thing that I think the PhilJA should also be involved in is, I don't know how to make this, that many judges should be really encouraged to be computer literate, because a lot of the delay would probably be lessened if the judges would be able to use technology to fast-track their work.
As far as the IBP is concerned, what do you think you can harness from the organization in order to help you in the administration of justice? And can you give specifics?
Okay, I was a commissioner in the Bar Discipline Committee, and I was able to handle a lot of cases involving lawyers. And I've noticed that the commissioners are usually appointed at the start of the term of the new president, and they are not full-time. And that is why there are a lot of pending cases involving lawyers. And somehow, there doesn't seem to be a process by which they could separate really the real cases that merit the attention of the IBP or the Supreme Court for that matter, and harassment suits are equally heard, and there's not really that much time for a commissioner who does it only on a part-time basis. So I think that the IBP should start hiring full-time commissioners to decide all these cases, because even in my case, there's a case that was pending for more than 7 years before it got decided.
You confirm, therefore, that there is no preliminary stage when it comes to disbarment cases?
There's none.
Okay. And as such, all of the cases, once filed, is considered a regular administrative case against a lawyer. Now, given that, the fact that there are commissioners, assuming that you have the sufficient number of commissioners required in order to resolve the cases, don't you think that it is also a problem that the Board of Governors that approves or that the recommendation and submits it to the Supreme Court should meet more than just once a month so they can act on these cases?
Yes, I unfortunately agree. The situation I know is quite difficult for the Board of Governors, particularly when there was a controversy and it took a long time before it was finally settled who would lead the IBP. So in normal circumstances, I would think meeting more than once a week would alleviate the problem.
So in order to nip it at the bud, what would you propose in order to filter so that only meritorious cases make it to the commissioner level and thus to be taken up by the Board of Governors?
There are many cases which, to my mind, were only filed as part of the strategy of the opposing party or counsel to intimidate or harass the other lawyer. So those cases should really not go through the whole length. But there are also cases which are really serious. In my experience as a commissioner, there were cases where the clients would give money to the lawyer to initiate the case, and years would pass, and they'd never file the case. That, I think, should really be heard fully, and the lawyer be given the chance to explain. And of course, there's also the question of conflict of interest. There are a number of situations I know where probably the lawyer didn't realize that he was in a conflict of interest position, and there's probably really a need for a lot of jurisprudence also on the matter, so it would be clarified when exactly is there a conflict of interest for a lawyer such that he should be stopped from handling cases. So I think just by the nature of the cases, you could already have some sort of filter system by which one would go only to the first stage and the other to the other, maybe the entire process.
And who do you propose should be in charge of filtering these cases?
I could only think maybe as an part of a law firm where probably there'll be a group of even young lawyers who would read all the complaints at the first instance and would be able to already see if these are just harassment suits or really serious cases.
Thank you, Madam Chairperson. For my final question, were there instances in your past wherein you found yourself in conflict with, well, in your case, you've only been in public service once, and this is your first year. You're still within your first year. But did you find yourself in any situation wherein your integrity and independence was put to test, since you would have to decide contrary to the wishes of the appointing power?
At SEC, we implement actually two basic laws, the Corporation Code, the Securities Regulation Code. We hold weekly and bank meetings. It's a collegial body. And my vote is actually just one of 5 votes. We discuss it openly in front even of our directors. And if there was ever a situation which would call for my disqualification to take part in the voting, then I would have complied with that. I remember one instance where I did not take part in the matter because it involved a Supreme Court case where one of the lawyers is my former law firm. But so far, as a regulator, I would think that they should expect fair and impartial resolution of their matters before the SEC.
So you never found yourself in that situation wherein your independence would be put to test?
None. As of now, maybe because it's only been a year, but I know that even if that time comes, even my friends and even those close to me or my former partners know how I will handle the case.
Thank you, Madam Chairperson. That was my last question. I wish you luck. Thank you, Mr. Chairman.
Well, Attorney Mejia, please.
Thank you, Mr. Chairman. Good morning, Chairperson Arbosa.
Good morning, Your Honor.
By way of a trivia, my lawyer assistant informed me that she was your former student. She's your former student, and that you used to share in their class that you trace back direct ancestry to Jose Rizal. Is that true?
Yes, Your Honor, it's true. My great-grandmother was Lucia Rizal, the sister of Jose Rizal. And since Jose Rizal didn't have any descendants, it's actually the great-great-grand nieces and nephews who are now, as we term ourselves, direct descendants of Jose.
Okay, that's interesting to know.
And I have an aunt, a grand aunt, the sister of my grandfather, who made the first Philippine flag.
Okay. Is this your first time to apply for the position of Chief of Justice in the Supreme Court?
Yes, although I was nominated, I can't recall when, to unsolicited nomination by someone who knew me to the Sandigan Bayan.
Because I'm just curious, there were various openings in the past. How come you did not signify your intention before to apply for the position?
Well, Your Honor, it's actually because of that case in the IBP. And it was just timely and opportune that it got dismissed before I had to accept the nomination for this position.
Okay, so just how prepared are you to be the next Chief Justice?
Well, I've been prepared since that thought came to my mind when I got that unsolicited nomination for the Sandigan Bayan Justice position. And, well, just to quote these often said statements, the dream of every lawyer, particularly in my case, a litigation lawyer, to be in the Supreme Court. Of course, it's just by accident that I'm applying for the highest position in the judiciary. I would have applied for a vacancy after, I would have complied with requirements.
Should the President appoint someone who is currently an Associate Justice, there will still be an opening for an Associate Justice. Will you still apply?
Yes,
okay.
of course.
So as a non-incumbent member of the Supreme Court, how do you intend to assert your administrative leadership over the 14 other Associate Justices?
As I said earlier, these are unusual times, and it may probably call for an unusual solution of an outsider being appointed. But thinking about it, it isn't really so much whether you're an insider or outsider. It's really whether you're equipped to lead and to master everyone, to realize that the goal is to move forward. Well, to be honest, I did read some books on what would be applicable to this situation I am in now. And there was this interesting book that talked about, and I think one of the nominees did mention it, about transformational leadership, that, okay, you have good leaders, but in the end, it's not the leader who would determine where the direction would be, but also those under him, and it's his job just to inspire and motivate them to realize that there is such a common goal, and they should consider pursuing that over their personal interests. In my case, I have complete trust that the members of the Supreme Court are all respectable people. They have rational minds, and I don't think it will take a lot to persuade them that this is what and how we should try and survive the crisis.
One of the questions that is usually suggested for us to ask lady candidates like you is your view on gender equality. So may I ask you, what is your view on gender equality?
Okay. Yeah, that crossed my mind too. That might be asked of me, and I said, why is it that the person in the scale of holding the scale of justice is a blindfolded woman? And I said, is it because it's supposed to show that the judiciary should have a heart, and it's a blindfolded woman who is the Lady Justice? But I think I'd like to look at it more as she's probably not really soft-hearted or not supposed to be the weaker of the two sexes, but more because she represents also the underprivileged or the weak. And that would include not only women, but children and all those others in unfortunate situations. And that's why probably she's the symbol of justice. She's supposed to represent those who are probably what they call less in law. But I wouldn't want to say that my philosophy would be to give advantage to those people, because everybody should have fair and equal treatment. But there are laws that really afford them special treatment, like, for example, our labor code that gives the benefit of the doubt in favor of laborers. Then in that particular instance, when you apply that particular law, due consideration should be given to the particular situation of the litigants.
Also, this matter of judicial activism and judicial restraint. What are you more inclined to adhere to? Judicial activism or judicial restraint?
I only answered that question last night. It was late at night. I was still thinking what it would be. For me, I have to say it's more on the side of judicial restraint. I do believe that the Constitution is adequately worded. You can understand what it is trying to say as the intent of the framers, and whatever decision you make presently, you have to go by whatever is said there as well as intended by the framers. If there's something unclear, then you just have to consider that intent and still stick to it. I am in favor of saying that there's really, the branches of government are really distinct and separate from each other, and that the less judicial interference in the activities of the two other branches, the better. But of course, the Constitution does provide for the judiciary stepping in cases of grave abuse of discretion of the other governmental entities. In which case, there should be no hesitation on the part of the judiciary to call to task the other government agencies who may have committed grossly abusive conduct or acts.
Okay, that's my final question. Good luck,
Thank you.
Chairperson Herbosa. Thank you, Mr. Chairman.
Thank you. Justice Lagman, please.
Thank you very much, Mr. Chair. Chairman Herbosa, good morning.
Good morning.
I was reading your personal data sheet and I noticed that you're still single. Is it by choice or by accident? Okay.
I'm sure it's by accident. Maybe there were opportunities that I could have changed my status. Although early on, we lived with the grand aunt who was single all her life.
Yes.
And the one thing I remember, what she told me was, if you're going to be single like me, just make sure you're independent. And I said, what do you mean by independent? And she said, you should be able to fend for yourself. You should be able to stand on your own. You should even be able to live alone, which I have done for some time. And in which case you're not beholden to anyone. You don't owe anyone anything. And you can do things without fear or favor from anyone.
Okay, thank you. So, now, Mr. Chairman, you have been heading the Securities and Exchange Commission since May of last year.
Yes, sir.
Can you tell us what you have accomplished
Thank you.
in that position?
Yes, it was a complete change for me from private practice to government, and it was also from, I would say, my specialization of litigation to the corporate field. But as I told the people at SEC, I'm so lucky that I went to this agency where many of them are really professionals. And the duties and functions of the SEC are all laid out into, I would say, very good laws, the Corporation Code, Securities Regulation Code. There are other commissioners. It's a collegial body, and we're all able to arrive at many decisions. Now, when I stepped in, I realized that one of the problems of the SEC is keeping up with the very entities that they regulate.
Yes.
And so I said, what are the things that we've been doing in order to computerize and to bring up to date our systems and procedures? And I was happy that the ADB had just conducted the study and said that that's really the way to go. And that's why we lobbied for a budget in order to complete this computerization project. So one example, right now we require companies which want to list in the exchange and submit registration statements to us to upload in their website these registration statements. On our part, we have also enhanced the website such that you can now view audited financial statements, general information sheets of companies. And in terms of acting as the registrar of corporations, we have opened, I think just 2 months into my term, the fast lane processing or the green lane processing unit, which is able to process registrations of corporations and partnerships in just 1 day. We've also entered into agreements with the Land Bank for them to be able to pre-process applications for incorporations. And not only that, we are in the process of revising the implementing rules and regulations for the SRC. We have already revised Rule 68, which adopts the Philippine Financial Reporting Standards for covered entities, and it has required more submissions, disclosures from covered entities in order to, I guess in the end, protect the investing public. I have also aligned and redefined certain departments within the SEC because I've noticed that one department was taking care of regulating the stock market, at the same time also doing enforcement actions relative to what would be possibly securities law frauds or violations. So I said that should be separated because there is some conflict there, that you have to investigate the very entity that you're regulating. So I created the Investor Protection Surveillance Department, or renamed one department as such, because that department used to handle pre-need companies, and pre-need companies have been transferred to the jurisdiction of the Insurance Commission already. So everyone has his own job to do. We are also into capacity building measures. We've been able to hire recently because maybe we were able to get a budget for increase in our compensation to the staff. One magna cum laude from UP Economics and another summa cum laude from UP Economics. We've also hired more lawyers. They're now willing to work for the SEC with our new vision. And the fact that we are now also sending we're 4 people to train abroad for master's degrees, and 2 here locally to be able to do further studies.
Okay, thank you very much, Madam Chair. In your opinion, what should be the role of the Supreme Court in shaping our economic policy?
I'm very much for the Supreme Court taking an active role, even in the limited function as reviewer of the law and not maker of the law. There are many cases that give the Supreme Court the opportunity to be able to contribute or to lead the country to better economic conditions. And I would always have in mind, if I were given the opportunity, to think about what the repercussion of a decision could be in terms of the economic situation of the country.
Okay.
I have an example, but it's a pending case, so I cannot maybe
I
talk
see.
about
It's okay.
it.
It's okay. The new constitution imposes upon the judiciary the duty, not only the power, to strike down acts committed by any branch or instrumentality of government in grave abuse of discretion. What do you think is the effect of this provision on the judiciary?
It's a very special provision that is probably present only in our Constitution. And it has really given the judiciary the enough power, although it's really a duty in a sense, to be at par, equal to the other 2 branches. And it is the final arbiter, or I would
Yes.
say the one who would say whether the 2 other branches have exceeded their authority. But as a practitioner, or even as a teacher or professor at the UP Law, I know that my students always have difficulty comprehending what's grave abuse of discretion. Of course, we have the usual whim, caprice, arbitrary, despotic
Yes.
manner, but they have not really been sub-defined to really be applicable to special situations. And maybe if there is a more definite illustrations given of what grave abuse of discretion is, then it would be a better guide for the judiciary, as well as it would contribute more to the requirements of consistency and predictability for Supreme Court decisions.
So, you have been in the active practice of law for the past several years. Are you familiar with the problems confronting not only the Supreme Court but the entire judiciary?
I would like to think so, Your Honor.
So can you name some of those problems?
Okay. In terms of delay, which I think everybody had mentioned before,
Clogged dockets.
yes, and clogged dockets. I would like to say, for once for all, I think our laws and rules are sufficient, except that some of these rules, which could solve the problem of delay, are not really being applied or implemented or followed. Like, for example, the modes of discovery. Some lawyers are still hesitant to avail of modes of discovery in order to shorten the trial stage of the proceeding. And then, for example, execution pending appeal. Do you know that it is still, despite Supreme Court decisions to the contrary, considered as an exception? If you have execution pending appeal after the decision of the RTC, let us say, then it would probably be able to reduce frivolous appeal. In my case, I was thinking we already have the verification, certification on forum shopping required from litigants. I think that if you're going to go appeal to the Supreme Court, I would require another statement in that certification that says that the client has been advised by the lawyer about the merits of the appeal or the lack of merits of the appeal, in which case then the Supreme Court can readily get an assurance that the appeal is substantive. Because I'm sure some clients would probably think twice before going on appeal and would, of course, not be encouraged by the lawyer to pursue a frivolous appeal. And sometimes there are also laws, like in the Civil Code, which allows actually property bonds, but if you go to the courts, they don't actually know about it, and they would rather get a bond from a bonding company, when actually property bonds would be even much faster. And there are other laws there already which would solve the problem of delay. Maybe it's more like what the Supreme Court did for mediation. I understand that it's been relatively successful and has lessened really the number of cases. And if I may point out, as having taught in law school for about 10 years, I've noticed that there's such an emphasis on remedial law subjects, about 25%. Even in the bar, it's really the major subject. And even if I am a professor of remedial law, I'd like to think that that shouldn't probably be the case. More subjects maybe should be given to arbitration, which presently is only an elective and probably only 2 or 3 units, and then mediation, and then probably teach students how to negotiate so that they avoid litigation, may be able to let the parties compromise and not go to litigation. So I could understand the hesitation of lawyers to go to that route, because then they probably won't be able to handle so many cases. But clients should also be educated that the bulk of the work of a lawyer is before the case. It is in the preparation, the evaluation, and if that evaluation shows that the case should not be filed, then the lawyer should be brave enough, forget about the fees, and say that maybe you shouldn't go to court for this one. So that's how I feel about it. And fortunately, while I was practicing law with my former law firm, we were told very strongly that if the solution is not litigation and if the case of your client is not meritorious, you have to be frank, honest, and tell them. You know, the reason why probably there is a perception of corruption in the judiciary is because some lawyers would overpromise and underdeliver. They would evaluate the case, and they know for a fact that the case is not meritorious, and still tell the client, oh, we can go to the court, we will win. And then when they lose at the first instance, they will say, the judge got paid by the other party. Because how else would they justify the fact that they had told the client that the case was meritorious? Yeah. And this thing about going up to the Supreme Court, I think could also be reduced if maybe our Court of Appeals would be strengthened, and people would trust that that decision is final and that should be accepted at that point. and that there's no more going to the Supreme Court, which I think should devote more time, of course, to questions of transcendental importance to the country.
Okay. How about the problem of corruption? That is a nagging problem in the judiciary. How are you going to address it?
Yes. Well, first of all, corruption is always counterproductive. Even if, for example, the lawyer will get what he wanted at the first instance, it would only result in doing bigger things when you go on appeal. But there's one way of probably minimizing the possibility of corruption. And I know that the Supreme Court, with the court administrator, does do its job to monitor and evaluate the performance of the judges in the lower courts, but probably making the process more transparent. I know that the decisions of the Supreme Court are now uploaded in the website. One suggestion that I heard and was told to me, to which I agree, is that you could probably also upload the memoranda of the parties. In this way, anyone, whether on his own or authorized by the Supreme Court, can do a legal audit of cases. Of course, decisions are not always supposed to be absolutely correct, but sometimes you can read through the lines whether the decision was not on the basis of the merits. And I guess being more transparent and making available to the public the filings of the parties, and then they compare what was the final decision, would probably give an impression of whether that decision was truly based on the merits.
Okay. Now that's my last question, but there is a question which we received via the Twitter for Chairman Herbosa. Now, can you tell us how a woman Chief Justice will manage the highest court of the land? What is your mission and vision for the court?
Yes, I don't think it will be much different from a man heading the Supreme Court. My vision for the court is that, as I said earlier, that everything should be based on the merits. The court should implement more reforms towards reducing the delay and decongesting court dockets. But the bottom line is it's really being able to dispense and administer justice in a fair and equal manner. But it is really among the qualities that the Supreme Court should have. To me, it's really the independence that's very important and primordial. Because from being independent, it all flows down to even with respect to giving everyone their fair shake.
Okay, this is my last question in connection with your answer. No, Madam Chair, do you think you possess a strong character to be above everybody, which would enable you to lead a court with moral ascendancy?
Yes. I truly believe that I have a strong personality. In fact, during my 33 years in Accra Law, and I headed the litigation department composed of 50 lawyers, mostly male,
Yes.
and I was able to, I came into the that position of being head of the litigation department of Accra Law at a time when so many other lawyers have left. And maybe they had no choice but to give it to me, being the one next in rank.
Yeah.
And I said, how am I going to manage this motley group of mostly young lawyers and try to regain the stature, the reputation of the litigation department of the office? But I was able to do it with the help of those young lawyers, and whom now have accomplished even perhaps more than I have, and I'm very proud of them. And it just takes a lot of consensus building, maybe persuasive skills on my part, and giving credit where credit is due to those who contribute to whatever job is at hand.
Okay.
In the SEC, I would say also that even if I was the newest appointee and the other 4 commissioners of course, have their own distinct personalities, I think that there has been no problem us acting as a collegial body.
Okay. On that note, Mr. Chair, I have no more question for Chairman Herbosa. Thank you very much.
Justice Hermo Sisimasera.
Good morning,
Good morning, Your Honor.
Madam Chairman. When in Genesis, when God created man, he he felt that Adam was lonely, and so he created woman from the rib of Adam. In your case, this is quite different. Don't you feel that God should give you a partner?
I've lived alone for quite some time, until recently when my sister who worked abroad for 15 years came back, and so now there are two of us. So I'm used to just being alone, Your Honor.
Well, considering that you have never been a judge before, it's best to remind you that the tremendous inherent power in the hands of the Chief Justice of the Supreme Court of the Philippines require that those appointed to the position should possess the highest degree of competence, integrity, and judicial prudence. Because the administration of justice is a sacred task entrusted only to individuals with the highest degree of competence. Now, what makes you believe that you deserve the position of Chief Justice of the Supreme Court under these reminders?
Thank you, Your Honor. Probably it's just a matter of self-confidence. Maybe it's something that I have come to that conclusion because of 33 years of private practice and 1.5 years of government service. Not in my wildest dream did I ever think that I would have this opportunity to apply not only for a justice position, but for the Chief Justice position, no less. It would probably be a leap of faith on the part of the appointing authority to choose any one of us, but I could see that all my co-nominees I would think have all those qualifications. I would like to think that heading the Supreme Court does require all those qualities, because even if you say that you're a graduate of law, you're a lawyer, you've taken your master's and all, it's probably through constant reading of Supreme Court decisions that you'll get to feel how law should be interpreted, and I've done that for 33 years. When it comes to independence, I've already explained my independent thinking from way back. Even my former partners in the office can probably attest to the fact that I'm willing to assert what I think should be done, what is just and right under the circumstances. And as to relationships with other people, I've, in my whole life, felt that people skills are very important, and I've always trusted and have faith in other people to always act in a civil and reasonable manner, and that there's no one, especially occupying such high position of Justice of the Supreme Court, who would not be able to discuss matters calmly and arrive at a reasonable decision. It's probably a matter of using persuasion, at the same time my skills in argumentation, but I'm sure that even the others would not anymore consider whether you're an outsider or you're a woman. It's probably how effective, how sincere you are in dealing with them.
We are aware of your excellent academic values. But don't you think that before being Chief Justice, one should first be an associate, at least an associate justice, or or engage yourself in work before lower courts, so that you can get acquainted with the intricate business of being a Chief Justice?
Your Honor, that would be an advantage. But I think it's an advantage that in other situations could be made up by other qualities or traits. And while I would say it would be easy for me to be able to learn the internal rules of the Supreme Court and to adjust to whatever situation the situation calls for, I'd like to think that since the Supreme Court or the Constitution did not require for an insider or someone who has judicial experience to be qualified for nomination, then I would like to think that the framers of the Constitution did give the benefit of the doubt to lawyers starting from law school and given the requirement of 15 years of experience, enough qualifications to fill up or to be appointed to positions in the judiciary.
If you are appointed Chief Justice of the Supreme Court, what would be your judicial philosophy?
As I said, my judicial philosophy would be probably characterized by what the Honorable Member Attorney Mejia said, that I will consider the Constitution as the law of the land. I will interpret according to what's said in the Constitution, and if that's not possible, then go to the intent of the framers of the Constitution. I realize where the three equal branches come in. We are distinct and separate from each other. The Supreme Court has the duty to be able to restrain the other government entities when it comes to grave abuse of discretion situations, but it should not unduly interfere with the functions of the other two branches.
What subject in law is your forte, Madam Chairman?
Well,
your expertise.
I thought I'm teaching, well, I stopped when I got appointed. I taught remedial law subjects like appellate court practice, civil law procedures, special proceedings, and all that. But if you're asking me about areas of law, I did do or handle a lot of cases involving contract law, public bidding, telecommunications. I even handled aviation cases, and I did a lot of estate cases. Practically the whole gamut of the law.
You did not
maybe
mention,
that was my...
you did not mention criminal law.
Criminal law. It's ironic, Your Honor, that I did get the highest marks in the bar for political law, where I got 97. And then for remedial law, I got 94, I think. And there was one other subject where I was told I also got the highest. But my lowest was criminal law. But fortunately, when I went to practice, that was where I thought I was most successful in. I was given the opportunity to handle a lot of criminal cases. I was able to get the first conviction for the piracy of cassette tapes. I also was able to get the first conviction for fake clothing, a case of unfair competition. And I did handle a criminal case for double murder and frustrated murder, and the person was convicted, although after I presented evidence, he did change his plea to guilt.
I'm asking all of this because you have to realize that the Supreme Court is a court of general jurisdiction. And so it's not enough that you're an expert in one part of the law.
Yes.
You should be well versed in all other subjects of law. So have you handled any heinous crimes like rape, murder, kidnapping, and all this?
Yes. We also got appointed the official for a kidnapping for ransom case. And as I said, I handled already double murder. In fact, the trial of that case was inside Muntinlupa because the person was already detained, and I don't know for what reason I had to go to Muntinlupa and present my evidence.
What did qualify you to be chairman of the Securities and Exchange Commission?
If Your Honor, please, I would think it's also my general practice. I handled a lot of commercial litigation. In fact, I do recall handling a case involving the stock exchange. I handled a lot of intra-corporate disputes when that matter was still within the jurisdiction of the SEC. And I did do corporate work before I went to litigation in my former law firm.
In other words, the chief executive considered you as an expert in corporation law.
I believe so, Your Honor.
Now, going to specifics, can an unlicensed foreign corporation doing business in the Philippines sue before the Philippine courts, taking into consideration the GTE, the Piatco, and other cases?
What I recall from jurisprudence, that unlicensed foreign corporation cannot sue if it had not gotten the proper license. But I do believe that there's also jurisprudence that says that...
So GTE cannot sue? Piatco cannot sue?
I don't know the circumstances of those corporations, but I'm just stating a general rule that I know is in several cases of the decisions of the Supreme Court, that if a company is not licensed to do business, unless it's an isolated transaction, then they do have to get a license. But in one case, I know that the company was allowed to get a license just before to pursue the case.
So if the problem of GTE and Piatco comes before you, how will you act?
Well, first of all, if they would be represented by ACRA, I guess I have to disqualify myself.
Does Piatco or GTE be considered as doing business under Section 3D of Republic Act 7042?
The definition of doing business is rather broad. Even just soliciting or offering for sale your services would be considered doing business. But if, as I said, they haven't had that activities on a regular mode, or it's really just an isolated transaction that they took part in some bidding, then they do not fall under the general prohibition of not being able to sue if you don't have a license as a foreign corporation.
Suppose the contract with Piatco was made in a foreign country. Can the problem of Piatco be solved by courts in the Philippines?
Usually, Your Honor, if the contract was made abroad, if there's no arbitration clause, then they could, I think, sue in the Philippines if that's their choice, because the subject matter of the contract involves a Philippine project. I'm not familiar with the
Considering
case.
Section 133 of the Corporation Code, this question was answered in the negative by, in the case of Van Sweden Brothers versus GTL Manufacturing, 523 SCRA 239. Now, you have never applied as a Justice of the Court of Appeals?
No, Your
or
Honor.
Justice of the, or Associate Justice of the Supreme Court?
No, Your Honor.
Not yet. So, from the private practice, you want to go up to the Chief Justice of the Supreme Court. Well, thank you very much, Mr.
Thank you, Justice.
Secretary Mosni, please.
Good morning, Chairman Nerbosa.
Good morning, sir.
Chairman Nerbosa, do you confirm that you are a direct descendant of our national hero, Dr. Jose Protasio Rizal?
Yes, that's how we term ourselves, as I said, since he himself didn't have any descendant. So all the descendants trace their lineage to him through the sisters or the brother.
Yes, thank you. With such an illustrious progeny, in your opinion, what specific qualities or virtues would mark Dr. Jose Rizal as our which mark Dr. Jose Rizal as our national hero, and which of these qualities do you possess and will be able to demonstrate and put to good use if you become Chief Justice?
I like to think that on a very personal level, the traits that I saw from my grand aunt and my grandfather perhaps were also traits that they probably learned from their uncle. And it would be stated in this way: you are not entitled to any advantage or preference in life. There's no such thing as sense of entitlement. You have to work for everything that you want, and in the process of working for anything that you want, you are not supposed to step on the shoes of other people or be unfair and unjust in your everyday dealings with other people. Of course, there's also the trait of being very thrifty, which Jose Rizal did have. He also was someone who was not afraid to work with his hands. Maybe almost at the same par as his novels. He also did wonders with agriculture. He set up this very good irrigation system in his exile time in the Pitan. And he was, of course, also a good eye doctor. I remember that he had also asked that some of his nephews, and that was including my grandfather, to go to the Pitan, where he taught them during summer things like reading, writing, and he would give them a lot of puzzles and learning skills, which I think I think was his way of contributing to the development of the youth. In Accra, while I was doing litigation, I suddenly had the mindset to transfer the technology of the skills I've learned. And while I was doing that in Accra itself and training the young lawyers to become good litigation lawyers, I thought, why not go to the law school and even then already impart to them what you've learned in practice and how they should really practice. And so I did go back to law school and started teaching in 2003. And I did get great satisfaction from the fact that I see my students, now lawyers, and sometimes they come up to me. And lately, one of them said that she'd like to work for SEC because she'd like to learn more things from me. And those are the things that give me really great fulfillment. I suppose if you look at the life of Sir Rizal, there was really nothing very, very great or significant because, of course, he was persecuted by the colonial masters, or he was treated unfairly and sent to exile, and then. But in his own little way, if you would read all his works and even his letters to his sisters, it would show the fact that he was independent, he was patriotic, very nationalistic, and that is what I also want to be known for, that while I did work for self-improvement, and probably why I'm in this position now, being able to apply for the high position of Chief Justice, it's how people probably viewed you in your everyday meetings with them would be more important to me.
Thank you, Chairman. Madam Chairman, are you a member of any particular faith community?
Faith community? No, I'm Catholic, and I'm not. But I'm not a member of any religion-related community. I am a member of Santa Club of Manila, Wilusi, of course, and I'm a member of the PDRCI, which is the Philippine Dispute Resolution Center, Inc. That's why because I've done a lot of arbitration in my.
In any case, how much of your personal faith do you think will influence your decisions as Chief Justice of this country?
I've learned that you cannot let personal beliefs interfere in how you decide matters, particularly if you are assessing the facts of the case, evaluating or appreciating the evidence. There are laws that provide for how this should be done, and that's what you should follow primarily. Personal beliefs or opinions should be set aside in the meantime. And it could be that I would decide something that probably doesn't go with what I believe in privately. But if that law is to be implemented, then I'll make my choice according to my personal belief.
Madam Chair, how would you put your experience and knowledge of corporate governance to effectively manage the judiciary?
I just gave a lecture in Kuala Lumpur early this year on corporate governance, and I noticed, because we were a panel of speakers from all over ASEAN, that our rules on corporate governance are at par with everyone else in the region, and there have been surveys done by private groups interested in the promotion of corporate governance that show that there's been good compliance. To my mind, the the objective of good corporate governance is so that people will have trust in those companies and will invest in those companies. And corporate governance is for the purpose of increasing the value of the shareholdings such that more investors would put in their money. So it's the same maybe for the Supreme Court. If we follow these principles similar to corporate governance, then the confidence of the people will probably increase, and they'd be willing to invest, rely on whatever decisions or pronouncements the Supreme Court will come out with.
Thank you, Paul. I have just two more questions, Madam Chair. Many big companies in the Philippines have embraced the concept of corporate social responsibility, or CSR, as part of their commitment to support the community, contribute to economic development, and improve the quality of life, environment, and society. My question is, what is your stand on legislating corporate social responsibility to be as a required part of operations in Philippine companies? How will you utilize this as an aid to the poverty alleviation program of the administration?
Maybe it's high time that we have a law specifically to encourage even more corporate social responsibility. I did notice as SEC chair that we do have a lot of foundations already in the Philippines, and foundations are subject to strict monitoring by SEC. Why is this so? Because they are recipients of big amounts, and they should be able to account for those fundings. Corporate social responsibility need not be mandated. I think each and every corporation should realize that the image of the company would be enhanced by doing not only what their businesses are supposed to be, but in helping the community. I recall a case I handled where the client had put up a big installation, but before they did so, they involved the community in the project, and they opened up all centers to inform them, to make them change some of their ways so that there will be less degradation of the environment, and to prepare them also for the installation or project of the company. And I think it was successful because there was not too much protest, and even now they're maintaining such community projects.
Salamat po. And as my final question, I think this is an important question to ask of you. Madam Chair, the JBC rules provide that candidates with pending administrative cases are disqualified from being nominated further for consideration by the appointing authority. Do you consider this to be a fair rule? Is a mere pendency of an administrative case a bar to candidates who are, for other reasons, qualified and deserving to join the judiciary?
Yes, that's quite a difficult question because in answer to the earlier question on why I have never applied before was because of the pendency of that case. But I truly believe that it should not be an absolute prohibition. Maybe you have to look into the merits of the case, because I said, unfortunately, there are people who adopt the strategy of intimidating the opposing counsels and filing many cases against them. I don't know, maybe for them to withdraw as counsel. For that particular case, I was also very much disappointed because of the fact that there were other lawyers with me in the team, and we were all cited as respondents. But it involved a charge which was that we had engaged in forum shopping, when precisely the very case that we filed was a petition for annulment of the judgment, which should really be filed with the CA, because you're seeking the annulment of the judgment of the RTC, which to us was because of the failure to give due notice to all the interested parties, when the law on reconstitution of title strictly requires such notice. So It was so unfair, but as I said, it's part of the hazards of the job. And the negative effect was that it did discourage me from applying for a judiciary position if that was because that may have been the rule. But I do think that more consideration should be given because there are, as I said, many people who have all the qualifications for becoming judges or justices, and they may have been victims of such baseless suits.
Maraming salamat po, Chair. Good luck po.
Thank you.
Good morning, Attorney Herbosa.
Good morning, Your Honor.
I think you appeared before us in Sandigan Bayan.
Yes,
You,
I'm happy that you remember, Your Honor.
Of course, lawyers from Accra. I remember that case because it involves the coconut levy funds.
Yes.
You know? So my question is, who was the party that you are representing then?
We represent in the coconut levy case CocoFed and some individual coconut farmers. I understand that CocoFed has been a client of Accra since way back, even before these cases were filed. And we did represent them. We were a passionate team of lawyers in Accra who handled this matter from 1986 when it was first filed. And unfortunately, I left before it was resolved. I think it was resolved, I was already at SEC, and it's now the subject of a pending motion for reconsideration.
Yeah. But you did not represent the shares of Mr. Cojuangco.
No, Your Honor.
In fact, you were on the other side.
I was for the coconut farmers who
Right.
were the beneficiaries of the investments made out of the coco levy funds, Your
Okay.
Honor.
Now, my next question is follow-up questions on disbarment, no? Because you were an investigating commissioner.
I was also a commissioner.
Probably during the time of Attorney Binduan, no?
No, it was during the time of former Solicitor General Cadiz. He was the one who invited me
Okay.
to be a commissioner.
So you are familiar with our resolutions? Huh?
Yes.
I refer to the resolutions of the court.
Yes.
If the resolution of the court is for IRR, it's investigation, report, and recommendation. There is a period within which the IBP should terminate. It is usually 90 days. Okay. Once you receive the resolution of the court, the case goes to an investigating commissioner. Okay. But of course, before you start the investigation, all the pleadings are already completed because we find prima facie evidence. But after the filing of the comments, that's the time that we refer to the IBP. Okay. Then the investigating commissioner will conduct an investigation. Yeah. The investigation. Yeah. Thereafter, the resolution or the findings of the investigating commissioner will go to the Board of Governors because his findings is only recommendatory. Okay? I'm still precise, Attorney Herbosa? Okay.
If I remember, it was quite some time ago. Yes.
Yeah, yeah. And then the Board of Governors will meet and deliberate on the recommendation of the investigating commissioner. Okay. Whatever is the recommendation or whatever the findings of the Board of Governors, whether admonition, warning, dismissal, or recommendation for the imposition of a disciplinary action, the Board of Governors will prepare its report, attach the findings of the investigator, and refer to the court. I mean to the Supreme Court.
Yes.
Then the Supreme Court, in en banc session, will tackle that recommendation.
Yes.
Yeah. Is that correct?
Yes, I know that, Your Honor.
You know, the problem is that some say that when we refer to the IBP, there is no yet administrative case to speak of. But do you recall that when a case is referred to the IBP, that case is already docketed with an administrative case number by the Supreme Court? You remember that?
Yes, yes.
Yeah. So that's also correct.
Yes.
Okay. So now go to the other point, another point. Now you are involved in family courts.
Yes.
I think you mentioned Tornel Garda. You were a part probably of those who came out with the IRR of several. Were you a part of the?
No more.
okay.
No, I wasn't a part of that anymore.
Are you familiar with the dockets of family courts?
With the dockets, no, Your Honor. Maybe just informally.
Yeah, informally, but you know
I heard.
but you know that there are many cases in the family courts,
Yes, Your Honor.
and the reason probably is the jurisdiction of family courts is broad and wide.
Yes.
Yeah. I give you an example. If a victim is a minor, if the victim is minor, and even if the case is only slight physical injuries, instead of that case going to the MTC on a rule and summary procedure, that case goes to the RTC and follow the regular procedure. Do you agree on that?
Yes, because the family court judges are specially trained to
Yeah, that's
handle
correct.
those
That's correct.
cases.
What I'm saying
Yes.
is that that's one of the causes of delay.
Yes.
Yeah,
As I said,
because if it is a slight physical injury, why refer to the RTC? Because the jurisdiction of the RTC in criminal cases is at least 6 years.
Yes.
But here, a slight physical injury, where the penalty merely is 1 month, should have been with the MTC on a rule and summary procedure, is it not? Yeah. So there's a problem on that. If you become a Chief Justice, what would you do with that problem? Because I think that jurisdiction, the court cannot change the jurisdiction of court. It is provided for by law.
yes.
Is it not? Do you agree with me, Attorney Tess?
Yes, I feel that the legislation regarding family courts, the creation of special courts to deal with the cases of children and women, have had the advantage of being studied and perhaps supported by data on how really cases involving children should be handled. And I think I would rely on the wisdom of the legislature in setting those parameters for
That's
the
the
handling.
that's the good side of it. But I was just talking one of the reasons why there is a high
Yes, that would
number of
cause-
cases now pending before the family courts. The other problem is that there are too many cases that are now filed before the court petition for annulment. Do you agree with me? Left and right, there are many annulment cases before the court.
Yes, Your Honor.
And probably the reason is that there is no way to separate the husband from the wife except through annulment. Is it not? Of course, you will not have that problem.
No, Your Honor.
Yeah.
But I've talked to a lot of lawyers who handle annulment cases, and they do realize their duty to
You're
not readily advise or tell them to go for annulment, but really give the whoever is the prospective client to first perhaps analyze or evaluate the problem first, see if it could be resolved, not
Yeah.
through annulment,
Yeah,
but through other means.
I agree with you. No? Now, my point is this. No? Despite the fact that it's very hard to get an annulment of case, because it's only under one ground, the psychological incapacity.
Yes.
Although the court has been not actually lenient, but in some cases, naging lenient ng konti. But if you look at the grounds for ground of annulment, it's very hard to prove psychological incapacity.
Yes.
If you're strict about it, is it not? Because you need the totality of the evidence. Okay. But you are a Catholic, you look at the grounds for annulment under
The church.
the church. And one of the grounds is the failure of the any of the contracting parties in performing the duties
Yes.
of a husband, and a father, or wife, and the mother. Is it not?
Yes.
You do not find that. You do not find that in our civil code. Do you agree with me? Is there such thing as if the husband does not give support to the wife or the children, non-fulfillment
Well, it could
of
be
duties?
taken in the general concept of psychological incapacity that he was not prepared to
No,
fulfill
but-
the
but-
duties of marriage.
Yeah, but that's only
But that had to be traced
that's
to
only
some-
one. That's only one part of
Yes.
psychological incapacity, because you have to
Yes.
take into consideration the totality
historical
of the
part
evidence.
it, Yes. So it's
No.
easier to get a church.
No, my question is this now. Do you think that it would be better to include that ground in the church, in the civil code, so that it will be assured to annul these marriages anyway? The husband and wife do not like anymore to live as husband and wife. In fact, some of them are actually separated. They do not live together anymore.
Yes. For yes, the law should really be applicable to the general population. It did not have to just probably cater to one group. And I am in favor of, if the final question is if I'm in favor of divorce, yes.
Oh, did you read my mind? That was my next question.
Yes.
So that will lead me to the question that do you think that it would be better that we allow divorce?
Yes.
Okay. Now I know you are familiar with the rules. In fact, you talk about modes of discovery. That's one of the modes of expediting cases, termination of cases. But the problem is, the court cannot tell the lawyer to avail of mode of discovery, because if you want to avail of mode of discovery, there are two ways. Before the pre-trial, you do not even need to have a leave of court, is it not?
Yes.
So at that
the
it should be at the
final
instance of the counsel.
Yes.
So it's not the fault of the judge. It should be, the lawyer should be taught
Yes.
that modes of discovery should be availed of, is it not?
In fact, the Supreme Court has noted in a lot of decisions the hesitation of lawyers to avail of the modes of discovery, primarily because only of the lack of awareness of probably how to do it.
That's what I'm saying.
Yes.
That's what I'm saying. I think it should be taught in the law schools.
Yes.
They do
Very
not-
much so, Your Honor,
Yeah.
because in the United States, I think the reason why they could really set a specific time within which the case should be finished, at least the trial, is because they've already gotten all the evidence through modes of discovery, and they only really present the vital witnesses.
That's correct. The other problem in modes of discovery, like in oral deposition in criminal cases, usually, can the prosecution file a motion to take the oral deposition of its witness?
If I'm not mistaken, Your Honor, I think in the criminal procedure, rules on criminal procedure, there are two provisions there that somehow are modes of discovery specifically applicable to criminal cases, and I think the
That's
prosecution
correct. That's
can.
correct.
Yes.
But the problem is this. I do not know if you read the case of Hubert Webb. Okay.
Yes.
The problem in criminal cases is that if you file a motion for oral deposition and the deponent's testimony will be taken, even if the accused is entitled to cross-examination, the accused can invoke his right to confront the witness. Unlike in civil cases, because there is no right on the defendant, on the part of the adverse party to be present. But in the case of a deponent in oral deposition in a criminal case, on the part of the prosecution, the accused always raise the objection.
Which to me is
And that is a constitutional right
yes,
to be
so
present.
it's primordial to
That's the
rules of
problem.
procedure. Yes, Your Honor.
Yeah, so we have to restudy also the role on rules on modes of discovery, both in civil and criminal cases.
Yes.
There is no problem if the accused is the one that will ask for the deposition of
Yes.
his witness, because
That's why the two provisions,
because the
one for the
complainant is not
prosecution.
entitled to be present in all proceedings in order to confront the witnesses. Do you agree with me, Attorney?
Yes.
Yeah.
In fact, that's the reason why I cited the case of People versus Hernandez, because the effect there was that pretrial rules for civil and criminal cases, they were trying to harmonize. And it did result in the court recognizing stipulation facts even in criminal cases.
Now, I'll go to another. I hope that if you join us as our Chief Justice, let us try to restudy the provisions on
Thank
modes
you,
of
Your Honor.
discovery. The other one is pre-trial, both in civil and criminal
Yes.
cases. Do you think that this is a tool to expedite?
Very much so. In fact, I did notice a change in the conduct of pretrial, because before, and because I've been in practice for so long, the pretrial was just the judge saying, "Oh, do you are you willing to compromise or not? None. Okay, we set it for trial." But nowadays, because of those rules that we have, you really have to present a pretrial brief. There should be a pretrial order, and the parties are warned that if you present more witnesses that you've indicated before, it should be for really, really valid grounds.
Not only that.
So it
if you-
does contribute to.
Not only that, in the rule for procedure in our environmental law,
Added.
we now require the lawyer to take their oath before the pre-trial, including the counsel. I mean, counsel and the party.
Yes, there are special rules for special types of cases which could probably be adopted for all, like in intercorporate disputes. In order to expedite proceedings, the parties are allowed to submit draft decisions, and the judge would just have to choose which one, or maybe adopt one entirely or in parts, which to me could also be adopted in some cases in general
or just
jurisdiction.
disregard, or just disregard,
Or disregard too.
the
Yes,
draft.
it's like also the use of commissioners,
Yeah.
where the judge would feel that he's not competent.
But
to
what's
go
the
for the
problem
facts.
on pretrial? Have you encountered some problems with the rules on pretrial in your practice? The new rules on pretrial?
Well, that's probably one of the things that should also be emphasized in law school. Not
Yeah.
only the trial proper, everyone is so concerned about direct examination, cross-examination. I think that should also be taught as a major part of the course on how to conduct or how to make the pretrial worthwhile part of the process.
Oh. Also, you talk about the rule on succession, no? Yeah. I had an experience about the intestate proceedings. I think I was not yet with the government service when that case was filed before my court. It was terminated when I was to leave my court as an RTC judge. I was able to
Effect a compromise.
Yes, effect a compromise because some of the compulsory heirs died already. It's in the records. The publisher of Iskra. I think you know the publisher of Iskra.
Yes.
But the problem in succession really is sometimes it's the rules. Is it not? It's the rules. Why? Because we allow multiple appeals.
Yes, in special proceedings, multiple appeals
Yeah.
are allowed, as well as in
Sometimes,
in expropriation. Yes.
Sometimes the main case is pending before the court, and the party raises an issue as to whether or not that is a compulsory heir. You go to the Court of Appeals, you cannot move, you cannot distribute because you will have to determine
Yes.
if it's a compulsory heir or not, or illegitimate or not, or he's an heir or so what.
Yes. Testate cases
then
do
you have
take
to
very
wait.
long. Yes, Your
So
Honor.
what should be done? If you come here, what should be done with those rules?
Well, I'd like to tell you my favorite Supreme Court case. It was the case was already in the Supreme Court, and the question was the delay in the filing of the petition for review, and it was revealed to the Supreme Court that the reason why there was a delay in the filing of that pleading, which caused the dismissal of the case, was because the wife of the lawyer had passed away. And that Supreme Court case, it's kind of relatively old. The Supreme Court devoted, I think, about 10 or 20 pages talking about how it is to lose a loved one and what a tragedy it was that probably was really a good reason for the lawyer to have missed filing the pleading on time. But then in the end, the court said the case is dismissed. Yeah. To me, it's a good way of showing how justice should be done, how the rule should be applied. You can't really be solving all these problems about delay and congestion if you do not apply fairly standard or uniform rule that if appeal is not right, that if you miss filing the pleading within the prescribed time, then there's no choice but to dismiss it. The problem sometimes is petitions are evaluated differently by judges, from one judge to another, from one division of the Supreme Court to another, so that the result is not uniform all the time. So sometimes there were times that it was very strict and would dismiss all petitions which do not even file legibly clear copies of the attachments. Then there was a time when anybody who, there was even a time that certifications or verifications signed by lawyers rejected and caused the dismissal of petitions. Those are really good rules because they would decongest the docket of the court, especially the Supreme Court. But I suppose that in the implementation, it should not vary from division to division or justice to justice, judge to judge. It should really be equally applied. And even if it's harsh, as in the case of the lawyer whose wife died and was not able to file the pleading on time, I think whatever is provided for should be applied.
Whatever it is, or a test, of course, you're qualified to be the Chief Justice. Whatever it is,
Thank you, Your Honor.
I will request Attorney Rolly Bindoan to recommend you to become a member of the Mother Committee.
Yes, for the revision of the rules.
Rules.
Yes.
Yeah.
I think you already on special proceedings because that's I think has
I
not
think so.
been-
Now, my last question, no? You may or you may not answer my last question. Is there an advantage of an unmarried woman Chief Justice over that of a married woman Chief Justice?
No, Your Honor. I think it's the same as what we follow in ACTA. You just have to be prepared for your cases. In your case, if you're the judge, then you have to read all the documents and go through all the evidence presented.
But you will have more time.
Yes, I believe so, Your Honor.
At that note, thank you. Thank you,
Thank
Chairperson Herbosa. Thank you very much
Thank
for
you.
coming.
Your Honors, the next to be interviewed is Congressman Ronaldo B. Zamora, now Senior Partner, Zamora, Poblador, Vasquez, and Bretana Law Offices. Thank you.
How will we address you, Attorney Zamora, Secretary Zamora, or Congressman Zamora? What is comfortable to us and to you? Shall we call you Attorney, Secretary, Congressman, or Ronnie? Just simple Ronnie.
Well, I've long been Congressman, Mr. Justice.
Okay.
It may be an easier
Okay.
nomination for me, yes. Thank you.
Do you have an opening statement?
Yes, as a matter of fact, I have, Mr. Justice.
Yeah. Now, we allowed candidates.
3 minutes.
Okay, 3 minutes. No extension. You may go ahead.
Yes, thank you, Mr. Justice. Good morning to the members of the JBC. Ano ang tingin ng marami sa ating hudikatura? Sabi ng research studies, pati ng ilan na ginawa na ng local at international agencies, pati na rin ang mga napakarami doon sa mga nominadong nauna sa akin, ang sinasabi nila ay ang napakarami sa ating mga kababayan ay naniniwala na ang ating mga hukuman ay inaanay. Inaanay ng lagayan, inaanay ng suhulan. Marami ang naniniwala na sa ating bayan nabibili ang hustisya. Na ang buong sistema ay hindi lang mabagal, kundi pabor sa mayayaman at pabor sa makapangyarihan. At nang hindi lang ang tama at mararapat ang hinihiling sa iyo ng buong sistema, kundi pera at mas marami, mas mabuti. Pagkatapos ng karanasan dinaanan natin ngayon sa impeachment, sa aking tingin meron tayo ngayong pagkakataon ngayon na baguhin itong ating kalagayan. Tingnan po ninyo, dahil sa ginagawa ng Judicial and Bar Council dito sa mga public interviews, ngayon ay nagkaroon tayo ng transparency at public accountability sa pagpili ng Chief Justice. Pag-isipan po natin, dapat ba natin gawin to sa pagpili ng ibang justices at ng ibang mga judges? Simula lang po ito. Nariyan ang realidad na hindi sapat ang ating pondo para sa buong hudikatura. Binabanggit na hanggat itong taon ito, less than 1% ng total national budget ang binibigay sa ating judicial system. Nariyan din ang katotohanan na maraming korte ay walang hukom. Binabanggit 25%. At kung meron, wala namang computers, wala namang storage facilities, kahit yung ordinaryong bangko sa ordinaryong judicial hall, madalas wala din. Maraming reforma ang kailangang pag-usapan natin para palitan ang kalagayang ito. Nariyan din ang katotohanan na ang kapangyarihan ng Korte Suprema ay nagmumula sa ating saligang batas at yan ay nawawalang bisa kapag ang hustisya ay hindi makamit ng sino mang naghahanap nito sa tamang panahon, sa anumang kadahilanan. Hindi lang ang Korte Suprema ang nakataya dito, kundi ang ating buong gobyerno at ang ating Republican form of governance. Ako ay sumali ngayon sa prosesong ito. Meron naman akong may haharap isang malawak na karanasan sa panunungkulan, konting talino at galing sa batas, at higit sa lahat, siguro po yung isang maalab na pagmamahal sa ating bansa at sa ating sistemang demokratiko. Sa librong A Theory of Justice, sinulat ni John Rawls ang isang mahalagang katotohanan. Ano po yun? Sabi niya, the idea of justice as fairness, justice as fairness, promoting equal distribution of benefits and burdens among all individuals in a society, is the way for the true ordering of a functioning system and society. In short, give the poor guy a break. Give the poor guy a break. That is the idea of justice as fairness. Give him more in law because he has less in life. Make this true and forever certain. And this is the call to our entire judiciary. Law cannot and is not the plaything of the rich and the powerful, but is in fact meant to be accessible to everyone, especially the poor and the disadvantaged. Lalo na po sa ating bayan. Araw-araw, dapat yan ang ating ipinapakita sa lahat ng lumalapit na ito ang bumubuo at laging bubuo sa ating isang mahusay na judicial philosophy. Ano po yan? All are equal before the law. Sa huli, ako'y naniniwala na malaki ang dapat natin gawin, kaya dapat natin simulan na natin ngayon. At ang ating gandipala ay napakalaki. Hustisya para sa lahat. mataas o mababa, mayaman o mahirap, meron o wala. At ang matamis na pagkabatid na sa darating na panahon, ang sasabihin nila dahil sa ating ginagawa ngayon. Ang sasabihin nila dahil sa mga nagagawa na natin ngayon. Ay ang sinabi ni Rizal sa huling yugto. There were those who kept vigil in the night of our forefathers. Hindi lahat ay naghimbing sa dilim ng gabi ng ating mga ninuno. Salamat po at handa na po ako sa inyong mga tanong.
Salamat din po. Attorney Cayosa, please.
Thank you, Mr. Chairman. Magandang umaga po, Congressman Zamora.
Magandang umaga po.
I will have to propound my questions in English. But feel free if you feel that you would be more effective in responding in Filipino.
No, let me try to be as fluent
Thank you.
as
You mentioned those who have more in law. I'm sorry. Those who have less in life should have more in law. Could you specifically state any program that you implemented in the past which would show this advocacy and how this could relate to what you can do in the future if appointed Chief Justice?
in Congress, many of the advocacies that I maintained were directed toward that objective. For instance, and of course it is now many, many years in the past, I was the one who sponsored the Comprehensive Agrarian Reform Program in Congress, and I moved it through the conference committees, and eventually it became law. Much of what is in the law right now is what was written by us, sponsored by us, and defended by us. Is this part of an idea that we should have a preferential right for the poor? Yes, of course. This is exactly what we want to do. And it should not be just in the law. It should also be in the ordinary discourse of life. It should be things that people will understand on a daily basis. So it is not just agrarian reform. It should be in every other important part of ordinary life. Let us try to bring the law into an ordinary person's activities, his needs, his desires. This is what is important. It is not as important as what lawyers tend to think are important. No, it is far more important than that. It is not just the practice of law. It is not what we are doing in our daily activities as lawyers. In fact, one of the things that I would like to see is more people getting involved in the law as a part of their daily life. For instance, napapansin po ninyo, and again, we will go back to the question of language. Nag-aalala po ako na ang nangyayari sa ating bayan ay nagkakaroon tayo ng parang dalawang lingwahe in the law. Ano po yan? English, which is used by our justices, by our lawyers, by our courts, and then Filipino, which is used by everybody else. We should start doing something about this dichotomy that we are now accepting as a fact. I think it is important that we bring the law into the lives of ordinary people, and we cannot do it in a foreign language. We cannot do it in a foreign language. Let us keep in mind that already we are 100,000 Filipinos, 100 million Filipinos. We are 12th largest in the world in population. And yet, every municipal or trial court that you go to, you will have court interpreters. Why court interpreters? Isn't this supposed to be courts in the Philippines? And yet we have to have somebody to interpret to the ordinary applicant for the law the language that is used by courts and yet is foreign to applicants. I am a little worried that because of this, the law becomes separate from the lives of ordinary people when it should be completely apart of the lives of ordinary people.
Thank you, Mr. Congressman. You know, when in the course of the interviews, most of the questions that we get always ask, what's in it for me? And you're talking about the common tao. So they would want to hear specifics. You know, how far with the proposal are you saying that we should conduct our trials in Filipino and no longer in English in order to make, they say, justice accessible to the poor?
No, I don't think that we can do this overnight, Madam. Clearly, the Supreme Court has already seen the benefits of using Filipino in courts. In fact, there have been studies. I have read one dated 2008 about one such study. But you will clearly have to provide for a transition of some sort. 5, 6 years, 10 years, I don't know. There are experts who can provide us the wisdom, the facilities for that. But clearly we cannot be understood right now by the ordinary people. Everybody who has been interviewed here is being asked through Twitter requests that people start talking in Tagalog, people start using Filipino. And I think at some point we have to face that reality. We are divorcing ourselves from the ordinary run of Filipino conversation. And is that a good thing to see? No, it is not. It is not. Clearly, we have to start reaching out. And if we can do it in our own language, why shouldn't we?
You've articulated what you feel is a priority. So in the making justice accessible to the poor, it's something that they should be able to relate with. But let's move on to something that perhaps you're more familiar with. You stated that the judiciary's budget is just a little, about 1% of the national budget. What would then be your priority if you become Chief Justice, given the limited budget that is given to the judiciary? What would be the first reform or program that you would be willing to spend on in order to address the needs in the administration of justice?
Well, first get more money, Madam. Clearly, money doesn't solve everything, but it helps. And why shouldn't it help? You have courts in Metro Manila where in some cities you have first-class courts with computers, with real facilities, with functioning air conditioning, for one thing, with real benches. And then you have courts in other cities, and they are really third world courts. I've seen better courts in places that you don't really go just for tourism purposes. Why is this? Why can we not have the kind of standards that will fit everybody? Why can we not have the kind of judicial halls that are not just a benefit to ordinary people, but a source of pride, so that people will say, tingnan ninyo mga korte namin. Talaga, pag tayo ay nagsasabi na sila ay nagbibigay ng katarungan, o tingnan naman ninyo kung hindi talaga kaya natin to. But you cannot do it with the kind of money that we have. Why is this important? Well, clearly because there are people who can help, like myself. I've been in Congress for almost 30 years. Since the Constitution was enacted in 1986, I have run in 6 elections and I've won them all. In short, I am familiar with the systems of Congress. If I were to help get the Supreme Court to be listened to, then can I do it? Yes, I can do it. Can I get people to say, baka naman si Mr. Chief Justice ay makakatulong para maintindihan naman namin kung ano talaga ang pinaglalagyan namin ng pera. Baka naman po. Baka naman yun na magawa ni Congressman Zamora. Ako ang tingin ko po, if we are able to double within the next 2 or 3 years our budget, then you will see tremendous improvements in the dispensation of justice in our country. That is one thing that we can do, and we must do regardless of what happens to me.
You are 67 years of age,
Yes.
stated in your PDS. That would leave you roughly 3 years in the court. You think you will be able to accomplish what you seek to accomplish?
I think you can make a real start. You can start in doing a few things, like getting better budgets. You can start in looking at the internal problems of trial courts. And in the last few days, one of the advantages or disadvantages of being one of the last in line is that practically everything that has to be said in the way of reforms has already been said. And I don't really need to repeat them for you, but you've heard most of them. You've heard about proposals that we take a look at judicial affidavits rather than the ordinary affidavits that we get. You've heard the possibility of using more extensively mediation and judicially supervised forms of mediation and compromise. These can all be done. There have been already so many proposals. By now, your ears are probably stuffed with every proposal that is possible. It only shows that people are serious about the system of review and interview that we have institutionalized. It is good that people prepare, because this time it is not just a question of who among the JBC do you know. It is more a question of what can you actually bring, what can you actually say, what can you actually propose. I think that is a good development that we should welcome. Are there many other things? Yes, of course, ma'am. It is important that we take a look not just at money, not just at methods. Let us take a look at technology. I am constantly surprised by so many pieces of paper being brought in to our halls. Why not start using small stuff? Like, for instance, a small iPad. What will this contain? Well, it has the facility to contain 10,000 books, for instance. That's a start. I do not use this just for interviews. No. Right now, I have in my iPad 1,600 books, real books. Real books. Shouldn't we be giving our judges exactly what Ronnie Zamora brings to this court? Shouldn't we be giving them not pieces of paper, but tablets, but iPads, iPhones, those that will connect them to the 21st century? Shouldn't we be doing that? These are small suggestions that I think in the end can help in the administration of justice.
I would really welcome that if you can double the budget of the judiciary.
I think we can. It is not a question of Congress not listening to proposals. They listen. They spend a lot of time on these things. It is that people are able to make a better case for their own requirements. In the end, what we need is some more money, and even better, a better presentation of what we need.
Thank you, Mr. Congressman. My final question. Given your long career in the House of Representatives, you are identified as a politico. You are also identified as an outsider.
Yes.
How do you think you will overcome this, let's say, characterization and the concern that you may not be independent in thinking?
Well, if it's a question of independence, first, just to answer the second point, I probably can claim a little more independence than the usual because, for one thing, I did not even vote for the president the last time around. And this is no great secret, I wasn't with him in the party. I wasn't with him in the elections. And if I were to show my vote, well, I'm not certain that his name appeared in my ballot. So does that give me bragging rights? No, it doesn't. But it gives me an idea that if I am appointed, in the unlikely event that I'm appointed, then I do not owe anybody a political obligation. I do not owe anybody a personal favor. I will simply owe myself and the constituents that I will try to serve a chance to do the right thing. And if that means that I will be a little more independent, yes, I think so. I think so. On the question of whether I am an outsider, yes, of course. I have never been in the judiciary. That is completely correct. But I think that I can enter the judiciary with certain useful skills in the other two branches of government that I have served. As I said, I have spent 20 plus, almost 30 years in 7 Congresses, and I have been majority leader in 2 Congresses and minority leader in 2 other Congresses. What do you need for these positions? Well, leadership, some management and executive requirements, compromise, of course, coordination. These are the things that you need in these positions. And I think they will be useful in the Supreme Court. These same skills are called for in the office of the President. When I was Executive Secretary, and of course this applies to every other Executive Secretary, you run a department that is even larger than the whole judiciary. Even larger than the whole judiciary. In short, much of the work in the Supreme Court will not be necessarily new or unusual to someone with a certain set of experience and a certain set of skills. I think that while I accept that I will be, in the first few months, an outsider, it will not take long for me to become not an insider, but at least less of an outsider.
Thank you, Mr. Congressman, and I wish you luck.
Thank you.
Thank you, Mr. Chairman.
Attorney Mejia, please.
Thank you, Mr. Chairman. Good morning po, Congressman Zamora.
Good morning po.
Senator Sagisag, in nominating you, wants you to be an interregnum Chief Justice. How do you intend to perform such a role?
Well, I really will have less than 3 years. I really don't think that I will do the kind of reform, the kind of changes that you want to introduce, the kind of new judiciary that everybody thinks of. But these are only available to people who are in their 40s and 50s, as some of our nominees are. How can I perform? Like I said, there will be certain skills that I can bring into the job. There will be certain abilities and functions that I can perform with some qualification. I have been executive secretary, and of course, and now perhaps I am looking at Undersecretary Musngi, coming from the Office of the President. The Office of the President, in the Office of the Executive Secretary, acts like a small Supreme Court. What does it do? Every decision of every line department is in fact appealable to the Office of the President. Just as, unfortunately, I think, far too many decisions are appealable to the Supreme Court. And at one point, I would like to discuss why this has happened. And perhaps it should not happen. But in the Office of the President, that is exactly the legal situation. Every decision from an executive department is appealable to the Office of the President. So much of what you will expect from a Supreme Court Justice or from a Supreme Court Chief Justice, you would have already been able to develop in the executive office, in the position of executive secretary. Do you have a legal department? Yes, and it is a large one. It is a very large one. Do you have lawyers who do nothing but decisions? Yes, you do. Are these decisions signed by them? No, they are not. Who are they signed by? By you as executive secretary. Is that any different from the work that an associate justice will do in the Supreme Court? I don't think so. Neither the Chief Justice. In fact, much of the work of the Chief Justice, which people say is 70-75% executive, is the work done by the executive secretary on a daily basis. On a daily basis. So what can I bring? In the 3 years that I can bring perhaps a new perspective, perhaps some talents that you have developed in your career in the executive and in the legislative branches of government. Perhaps you can be able to say, well, a lot of the things that you are looking at, I have looked at. It is not necessary to keep looking at every system and every question as a matter of reinventing the wheel. No. What you can bring is precisely that. Some ability, some experience, and perhaps some usefulness that you can bring to the Supreme Court.
The didiretso na po ako dun sa mga tweeted questions para naman may accommodate natin. No? The first two tweeted questions that I would like to read are interrelated. Yung una po, hindi ba problema ang pagiging politiko ninyo sa pagpasok ninyo sa Korte Suprema? Yung pangalawa po, should a politician head the Supreme Court? How can you shed your political past if up to now you would like to be addressed as congressman?
Hindi naman po, one of the more successful Chief Justices was Chief Justice Fernan. And way before he entered the judiciary, he was in politics. And he was pretty successful too, representing a real constituency in Cebu. I don't think that politics is that far from the judiciary in the sense that both are really part of public life. I think you can make an easy transition if you do not carry too much baggage. And that really asks me now, do I have baggage? Yes, of course, everybody has. But do I have enough so that I should be disqualified? I don't think so. But that is, of course, not for me to decide. That is for you to decide. In the end, I have some experience, I have some qualifications, and I think I have the kind of heart that is needed. It is not a question of being a politician. I don't think that is a disqualification. In fact, I would think that it is a qualification. It gives you a better sense of how to deal with people. It gives you a better sense of how to answer questions and how to supply solutions for very large problems. Whether you are in the judiciary, whether you are in Congress, whether you like to be addressed as attorney, as I could have so easily said, why don't you just address me, Justice Peralta's attorney? But that is not being honest. I think everybody calls me congressman. Why don't I get called here? I would look a little plastic. And that's not exactly what you want to see sitting before you.
Paano ninyo susugpuin ang practice ng huweting lords, ng pagbibigay ng huweting money sa mga public officials, kabilang ng maraming judges?
Matagal na yung problemang wetting. Ako, sa tingin ko, ang wetting ay tanggap ng ordinaryong tao. Kung titingnan ninyo, hindi nila tinitingnan ng wetting yung ito piso, ito 2 piso, tumataya ka. Ang katotohanan ay, nung kami ay nasa gobyerno, tiningnan namin mabuti kung pwede malegalize ang wetting para hindi lang ang wetting lord na nakikinabang, kundi ang gobyerno. Sapagkat kung rini-regulate mo, ibig sabihin, pinapatawan mo ng taxes. Ano nang nangyayari dito? Walang taxes ang gobyerno, suhol ang nakukuha ng pulis at gaya ng sinabi nila ng mga politiko, yung ba ay mas maganda? Sa tingin ko, hindi magandang kalagayan yan. Hindi po. Mas mabuti pa na pag-aralan natin ang mabuti. Tingnan natin kung paano natin magkakaroon ng isang kalagayan na lahat ay nakikinabang. Maski anong gawin mo, ang tao ay tataya. Kung tataya ang tao, tingnan naman natin, baka pwede hindi lang pulis, hindi lang politiko makinabang, kundi ang gobyerno. Ibig sabihin na babalik sa ordinaryong tao ang linalagay niya sa wetting.
Hindi lang mga huwes. Salamat po. Yun na po yung panghuling katanungan ko and good luck po, Congressman Zamora.
Justice Lagman, please.
Thank you very much, Mr. Chair. Congressman Zamora, good morning.
Good morning.
Dahil po kayo ay nagsalita sa ating wikang pambansa, ay pipilitin kong magtanong din na gagamitin ang ganong wika. Okay. Sa 3 taon na itatagal ninyo, kung kayo po ay matatalaga bilang punong maestrado ng ating kataas-taasang hukuman, paano ninyo magagamot o maaalis ang mga anay na binanggit ninyo kanina na sumisira sa ating hukuman?
Alam po ninyo, hindi naman ang mga WES ang may problema lamang.
Sino po?
Kami po ay private practitioners. Meron po kami maliit na law office. Nabanggit na din po ito sa mga interviews. Ang problema sa atin ay ang pagtanggap sa mga desisyon. Kung ang tingin natin ang sistema ay pabor dun sa mayayaman at sa mga makapangyarihan, maski anuman ang desisyon, ang titingnan, ang sasabihin ninyo ay nabili ang katarungan dito. Hindi patas ang lagay ng ang takbo ng desisyong ito. Ano ang pwede nating dapat gawin? Unang-una, palitan natin ang idea na pag pumunta ka sa korte, panalo ka o talo. Yun ang matagal ko nang sinasabi sa aking mga kasama sa opisina. Hindi naman lahat ng kaso kailangan ipanalo. Ang katotohanan ay mahalaga na samahan mo ang tama. Kung tama ang kliyente mo, mas mabuti. Kung hindi tama, di ituro mo sa kanya kung paano dapat niya tanggapin ang katotohanan at kung pwede, tingnan ninyo kung meron siyang makukuha pa dun sa kalagayang yun. Napakahirap po sapagkat sa atin ang tingin natin, I have to win it. If I don't win it, then I've been cheated. Parehong-pareho sa politika. Pag hindi ka nanalo sa halalan, ang sasabihin mo, kaya lang naman ako natalo, nadaya ako eh. Sa korte, ganun yun. Pag hindi ka nanalo, ang sinasabi mo, nabili yung wis eh. Yung abogado ko, linaglag ako. Ako ang tingin ko, justice, dapat tayo magsimula sa ating mga eskwela. Dapat tayo magsimula sa ating mga pamilya. Dapat tanggapin natin na hindi lahat ay dapat ipanalo. Sapagkat hindi naman lahat na ikaw ay kalahok. Hindi naman lahat kayo lang ang tama. Paano yung kabila? Hindi ba din sila sa kanilang paningin? Tama din sila. Kaya yan ang dapat natin simulan. Isang pagbabago at pagtanggap sa katotohanan. Hindi lahat ay para sa inyo. Hindi lahat ay para sa inyo sapagkat kayo lang ang mga anak ng Diyos. Ang katotohanan ay ang buhay natin napakahirap. It is para sa Facebook, hindi ba po? It is complicated. Ang katotohanan ay ganyan talaga. May tama, may mali. Sana mas marami yung tama sa buhay mo kaysa yung mali. Kaya lang hindi mawawala yun. Ang masama ay pag sinabi mo, tama ako, natalo ko, nadaya ako. Binayaran yung wes, dinaglag ako ng aking abogado.
Okay. Congressman, kayo po ba ay sasang-ayon sa sasabihin ko na ito ay katungkulan ng isang abogado na ipaliwanag sa kanyang kliyente kung anun talaga ang kalagayan ng kaso? Kailangan ba na ituloy ang kaso? Mayroon ba siyang pagkakataon na manalo sa kaso? O hindi na?
Kami po, yan po ang ginagawa namin. Kaya maraming tumatanggi sa amin.
Ganun po ba?
Kaya lang ang katotohanan ay ngayon lang sa simula ng kaso, sa gitna, lumalaki ang gastos. Nagkakaroon hindi lang ng emotional investment, nagkakaroon ng financial investment. Pagdating ng panahon, yung kliyente mo mismo nagsasabi, hindi natin pwede ipatalo ito. Dapat right from the beginning, gaya ng iniisip natin para sa ating hudikatura, right from the beginning, we tell the truth. We say, hindi naman panalo ito eh.
Yes.
Ang katotohanan, wala naman tayong karapatan sa lupang pinaglalabanan natin.
Tama po.
Hindi po yun eh. Meron ba kayong narinig na abogado na nagsabi, wala naman tayong panalo?
Yun nga po, yun, palagay ko po, yun ay kasama sa suliranin ng napakaraming kaso na natutulog sa mga hukuman. Kasi po ako po ay naging hukom din at nakita ko na maraming kaso na ipinadadala sa ating hukuman na hindi karapat-dapat na maipasok sa hukuman.
At tingnan ninyo, hindi ba yan ang dahilan kung bakit napakarami ng mga kasong nakabimbin sa ating mga dockets?
Kaya nga po. Kung minsan, dahil nga ako sa kadami ng kasong pumapasok, hindi magkaroon ng panahon ang hukom na tingnan talaga kung minsan yung pumapasok, first come, first serve, we attend to those cases which were first
At
filed.
gano'n naman talagang dapat, hindi ba po?
Anong nangyayari po, yung mga huling napasok na hindi naman karapat dapat talaga na dapat ma-dismiss na antimano, ay hindi ma-dismiss dahil wala pang panahon ng hukom na pag-aralan yung kaso yun. Kaya po yun ang nagiging dahilan.
Paano pumunta po kayo sa Maynila, sa San Juan, sa Metro Manila Courts? Humarap po kayo, 20 kaso bawat araw. Hindi po unusual ito, hindi.
Talaga po, naalam ko
20-30 cases a day.
I know.
Ano nangyayari? Doon sa 30 yun, dalawa lang ang pagkakaroon ng hearing.
Opo.
18, 28.
Yes.
Ipopospone. Sa palagay mo ba, Justice, sa palagay ba po ninyo, yung mga nandun, yung nakaupo doon, yung mga kliyente ninyo, sa palagay pa po ninyo, sinasabi nila, naku, napakaganda ng sistema ng dispensation of justice natin.
Yes.
So ano nangyayari? Doon sa dalawang yun, hindi ka pa sigurado kung sino mananalo at sino matatalo.
Yes.
But you have 28 others who have spent money on their lawyers, who've spent money of their own.
Yes.
Umuupo doon, tapos ang sasabihin, postpone, reset. Alam po ninyo, pag na-reset ngayon, hindi yung next week.
Yes.
Hindi yung 2 weeks.
Naiintindihan ko po yun.
2 buwan,
Yes.
1 buwan, 2 buwan.
Yun po talaga ang napakalaking problema.
Kaya napakahalaga para maintindihan ang kalagayan ng Supreme Court. Tingnan po ninyo, sa Amerika, ang mga sinasabi ng Supreme Court talagang pinakikinggan, binabasa, talagang pinaglalabanan. Yung huling decision ng Korte Suprema dun sa Obamacare, yung health,
Obamacare, yes.
universal health
Opo.
coverage. Tingnan po ninyo, hanggat ngayon, pinaglalabanan pa. Dito, ang Korte Suprema natin maglalabas 6, 7 sa isang araw. Sino nakakaintindi? Merong ang nag-iintindi, yung nanalo, na tuwan-tuwa, yung natalo na sinabi nabili ang Korte Suprema. Yan ang kalagayan natin. Because we allow every case that is possible to be filed. And from filing, you start this very long process. Meron po akong personal experience dyan. Nung ako'y nag-aaral sa ibang kaso, nakita ko yung isang kaso. Nagulat ako. Espina versus Zamora. Iniisip ko,
Zamora.
wala naman ako natatanda ang kaso. This was decided a year and a half ago. Espina versus Zamora. Ang ponente po si Justice Abad.
Ah,
Noong 2000, meron ng Kongreso, nandun po ako. Hindi, wala na pala po ako. Executive Secretary ako. Nagkaroon ng kaso, meron kaming pinasok sa Kongreso ng isang panukala, Retail Trade Liberalization Law.
okay.
This was passed March 2000. Dinimanda po kami ng ilang mga congressman. Kailan po natapos? October 2010.
Wow.
10 taon para sa isang ordinaryong kaso. In the end, affirmed naman ang decision, ang ginawa ng gobyerno. Paano po kung hindi gobyerno ang isang party doon? Kung palagay ninyo kayo ay isang ordinaryong mamamayan, nagkaroon kayong kaso, sa palagay po ninyo, pupurihin ninyo ang sistema na 10 taon inabot yung kaso ninyo? Ordinaryo pa nga yun eh. Ang katotohanan, titingnan po ninyo yung ilang mga kaso decided by this present court. Yung iba, pirmado ko po nung ako ay Assistant Executive Secretary in the 1970s.
Ganun po ba?
Yung iba ay umabot na ng 30 years. Hindi po ito biruan.
Yes.
Ito po ay kahanda ko pakita sa inyo yung mga kaso. Kaya lang, nakakadismaya na gano'n ang sistema natin. Kaya napakahalaga na pagkatapos po nito, hindi importante kung sino ang pinili ninyo. Importante, let us take a look at the system of dispensing justice in this country. Let us do something good. Let us do something right. And that means not just declogging our courts, because our courts are drowning in cases.
Yes.
Let us see what we can do so that people will sue less and will understand justice more.
Okay. Now, pupunta naman po ako sa korupsyon. Kasi po, isa sa napakalaking problema sa hudikatura ay may nabanggit kayo kanina tungkol sa korupsyon. Maging totoo man yun o hindi, na ginagamit lang kung minsan ng abogado,
Opo.
na nagbigay sila sa hukom, ay ito pong issue ng korupsyon ay talagang isang napakalaking suliranin sa hukuman. Kung kayo po ang magiging punong maestrado, ano po ang binabalak ninyong gawin para kung hindi man masugpong lahat, ay mabawasan ang korupsyon na ito sa hukuman?
Unang-una, dapat kausapin yung mga huwes. Unang-una. Pangalawa, kausapin yung mga abogado. Pangatlo, kausapin yung general public. Bakit po? Yung mga huwes dapat sabihin, I am not going to start a witch hunt. I'm not going to say, I will remove 30-40% before this is over, and that will put the fear of God in the rest of the 70 or 60% that are left. Bakit? Sinira mo na din yung buong sistema ng korte. Ba't hindi nilang sabihin, eto, kalimutan natin ang mga nakaraan, o henceforth, gagandahan natin ang sweldo, bibigyan namin ng magandang facilities, aayusin natin ang pamamalakad, but no fooling around after today. Hindi ba po mas mabuti yun kaysa yung ang ginagawa natin, we are allowing the system and the problems of the system to fester. Pangalawa, yung mga abogado, sila ay may responsibilidad din. At sila din ang mga nasisira. Kung ang korte ay nasisira, hindi ba they have as much at stake in this
Yes.
as the courts? And they are, in fact, often responsible for much of what is happening in the courts.
Yes.
Talk to them. Tell them, baka naman pwede. Huwag na natin sasabihin sa mga bugad, sa ating mga kliyente, itong kailangan natin.
Yeah.
Si judge, may 2 desisyon. And you have heard this. Yung isa ay pabor sa atin, yung isa ay laban sa atin. Kinakausap po kami ng mga abogado kung ano ang ilalabas. Hindi ba mas mabuti sabihin, Mr. Lawyer, sabihin naman ninyo doon sa mga kliyente ninyo, I will do my best. This is where the law is. This is where our case is. At sa tingin ko, may laban tayo, kaya lang I cannot guarantee results. At huwag tayo hihingi para sabihin, kailangan to ni judge. Yun lang napakalaking magagawa. Pangatlo, sabihin natin kung anong ginagawa natin sa general public. This will make the whole system transparent. And if we are able to do that, then we will spare future generations of what we are going through. I think it is important that we make a start, and the JBC will play a tremendous role in this.
Okay. Now, Congressman, ito na lang po ang aking huling tanong. Kasi po baka nagugutom na rin kayo. May sinabi kayong kanina na para natin masugpo ang korupsyon, kailangan taasan natin ang sweldo ng mga hukom at ng mga kawani ng hukuman. Kung gagawin po natin yun, kailangan nating humingi ng dagdag sa ating budget. Kayo po ay naging kinatawan dati at palagay ko ay alam ninyo ang dapat gawin. Pwede ho bang sabihin ninyo sa amin kung kayo ay magiging mapalad na maging punong maestrado, ano po ang gagawin ninyo para madagdagan ang budget ng hudikatura?
Unang-una, dapat natin pakita kung anong napakalaking capital requirements para sa ating hudikatura. I'm surprised that we are not as computerized as our law offices.
Yes.
Maski anong law office puntahan ninyo, wala ng mga sekretarya sapagkat lahat ng mga abogado, they are computer literate.
Yes.
They research, they do their own typing, everything is available.
Opo.
Tingnan po ninyo, isang suggestion. Narinig ko po si Justice Carpio at sinabi nila may program sila of giving thumb drives. Alam po ninyo, ang problema, yung thumb drives, nakita po ninyo yung thumb drives.
Yes.
Ganyan kalate po yun.
Opo.
Napakadaling mawala yun. Napakadaling nakawin.
Yes. Opo.
Ang dapat po talaga, isang technological survey of our court system. Bakit? Yung isang 1 terabyte of memory storage will be enough for every single court in this country. So bigyan ninyo bawat korte ng 1 terabyte. Ano?
Naku, baka hindi po makaya.
Napakamura po nun. You're not talking big bucks. You're talking of
Okay.
$200-300
Okay.
for storage capacity. Ano ibig sabihin po nun? Hindi na nawawala ang mga court records. Hindi na hahanap ka sa mga filing cabinets kung ano yung decision. Lahat yun ay nandun. They are not only researchable, they act also as your own memory, your own storage, your own data keeping. Yung ganun simpleng bagay ay magbibigay sa inyo ng facility na, o dito, ito ang napakagandang pagbabago sa ating korte. Siyempre, iniisip ninyo, hindi ba dapat may central unit? Tama po. Ilagay po ninyo sa Korte Suprema. So lahat ng kaso, wherever in the Philippines you may be having a case, lahat po yan available sa Korte Suprema. Available to the entire judicial system. And then, probably in some vault, in some government office, you will have a backup again. But that will make sure that the facilities that are now available to offices like the LRA, yung Land Registration Administration, that should be made available also to the judiciary. Yun ang sinasabi ko na, sa tingin ko, siyempre, dapat pag-aralan. This is not just Ronnie Zamora talking or making some preposterous proposal. No. But it can be done. It can be done for much less money than is expected.
Okay. Yun na pong huling katanungan ko sa inyo, Congressman. Pero meron pong nagpadala sa amin ng katanungan na nakikiusap na kung pwede daw po ay itanong sa inyo.
Opo.
Kaya kung papayagan niyo po ako, ay babasahin ko yung tanong niya. Actually, Tagalog din ho yung tanong eh. Ang sabi, tinatanong po niya kung ano daw po ang naging asosasyon ninyo nung kayo nasa pamahalaan kay dating Pangulong Marcos. At kung kayo daw po ay magiging punong maestrado ng ating bansa, ano daw po ang gagawin ninyo sa mga kaso tungkol sa kanya at sa kanyang pamilya?
Ako po ay nagsimula sa gobyerno sa panahon ni Presidente Marcos.
Opo.
Nandun po ako hanggat napalitan ng gobyerno.
Opo.
I served in various capacities. And I always thought of him as not just the president, I always thought of him in a slightly more personal way. I thought of him as a mentor.
Yeah.
Madalas po sabihin sa akin ni Presidente Marcos, kaya kita naman kinakausap sapagkat pareho tayong dinaanan. Ano pong ibig sabihin nun? Pirmi niyang kinakantsuan na dalawa daw ang number 1 sa Malacanang. At hindi lang ako. Ibig sabihin pati siya.
Opo.
Tama po yun.
Opo, pareho kayong
So
number
it is
1,
not,
first placer.
it is not a question of Pangulo lang siya. Hindi po. Anong gagawin ko sa mga kaso? Well, malinaw naman ang sagot, hindi ba po? Justice.
Kaya lang po, para
Dapat po,
malinawan.
yung mga kaso matapos na.
Tama.
The Marcoses are old enough, they are mature enough, they can defend themselves properly. Bakit hindi natin tapusin yung kaso? Ano man ang desisyon,
Kalabasan.
sa tingin ko, after 30 years, matapos na lang yung kaso, pati sila ang pamilyang Marcos ay magpapasalamat. Like anybody else, nobody wants a case that drags on for 30 years. Hindi lang ordinaryong tao, hindi lang mga Marcoses ang nakataya dito, lahat tayo. None of us wants to be subjected to 30 years of having to go to court.
Okay. Salamat po ng marami, Congressman. Thank you very much.
Salamat po.
Justice Hermosissima Serna.
It's now good afternoon,
Good afternoon po.
Or is it Senator? I have had a very high regard for you, for your political prowess and your legal mind.
Salamat po.
When you lectured on the barristers at the UP in 1952. Still remember that. I was one of the barristers then. Congressman, you topped the bar because you are very good in English.
Opo. Sana hindi lang po English.
Why do you want to disregard English in our dealings in the Philippines?
Hindi naman po justice na i-disregard natin English. Kaya lang po dapat buksan natin ang ating paningin upang ma-develop tong wika na.
You see, Congressman, in high school, I had the grade of A in all subjects except Filipino. At the time, Filipino was introduced, and I got C in Filipino. And so I did not become valedictorian, I became salutatorian only. You see, English is a lingua franca of the world. That is the advantage that our OFWs have. Because our Filipinos know English. And then, didn't you realize that Cebuano-speaking people are more in number than in Tagalog? You see, the only unifying factor among these people is English. The only, most of the, there are some people in Mindanao who speak Tagalog quite well. Most of them are come from Bilibid prison because they've been acquainted. Yeah. There was a time when my father had a case here in Manila, and his disadvantage was that he did not know how to speak Tagalog. Well, as I said, I have a very high regard for your legal mind, and I have no doubt that if you are appointed Chief Justice, you will, the country will have an excellent candidate for that position. So on that note, thank you very much.
Thank you, Justice. But let me just say a little something about language. You know, Justice, this is one of the important questions in our national life that we have always pushed under the rug. Sooner or later, we have to come to one basic reality. English is no longer used with the same facility, with the same usefulness as it was when I was taking up law. I finished my law in 1969. I'd like to think of myself as a young man, but the truth is 1969 is so far from where we are now that I have forgotten many of the things that I thought I would never forget. And why is that, Justice? It is because things change, life itself changes. I suppose when my father, who was a lawyer too, who studied in the United States for his law, when he came back and he started talking in courts, in English, people looked at him askance, and they said, why English? When everybody studied Spanish. But in the end, it is always life that wins out. Spanish has fallen by the wayside. Eventually, English will end up in the position of Spanish, and we will end up with English being used by call centers, by BPOs, by multinational companies in the Philippines. Yes, it is lingua franca right now. But if I were to make a bet, Justice, if I were to bet on other languages, I would bet on Putonghua or Mandarin as the language for the next century rather than English. It is simply because there are far more people speaking Putonghua than are speaking English. It is not a matter of choice, Justice. It is a matter of accepting some realities. And the reality is more people are speaking Tagalog than are speaking English.
Okay, are you through? Secretary Mo Musngi, please.
Maraming salamat, Chairman. Good afternoon, sir. First of all, I'd like to disclose that I was a former volunteer lawyer of Attorney Ronnie Zamora when he ran for the second term in his legislative district, that is the District of San Juan.
I probably did not thank you, Undersecretary, but thank you now.
Thank you po. At I also am a very good friend of your daughter, Consuelo Cello, who unfortunately passed away some years back. I continue to commiserate with you and your family on that loss. So my first question is, how are you, Attorney Ronnie Zamora? How have you coped with a loss of one very precious daughter?
I'm sorry. This is a question that has caught me off guard, but my daughter was a lawyer. She studied in Ateneo, which I used to tease her that I didn't even know that Ateneo had a law school. But she was a good lawyer, and she was a painter. She wrote. She did a lot of things, but at 38, which means that She passed on 4 months, 4 years, 5 months, and 20 days before today. I have tried to cope. I have tried to put up a small foundation so that I can help fight what she died from, which is acute myelogenous leukemia. Acute myelogenous leukemia, if you catch it when you are young, there is a good chance that you will survive it. It doesn't cost that much, Undersecretary Muski, to save children in there when they are 5 or 6, because their immune system is still, while impaired, is still around. When my daughter was dying in Houston, every day that she was there, her numbers would drop to 0. Every day. That is because when AML strikes you and you are past a certain age, it is almost certain that you will die. We tried to fight it. Her doctors told me that there is no chance. But trying to be a good father, you will not accept even reality like that. And so we fought it. I organized a small group of Filipinos in Houston because she needed white blood transfusions every day. And since you are not allowed to give white blood transfusions more than once every 4 weeks, you have to organize a small group. And people, many of whom I did not know, they came and they started this system of rotating donors. And we were able to do that, but unfortunately, being a lawyer, she signed what is called an NDR. It is do not resuscitate. She had a heart seizure, and she underwent cardiac arrest. She could have lived, except she had signed her own, in effect, death certificate. She did not want to live under those conditions, and the doctors allowed her to pass on. How have I coped? Well, it has not been easy, but you will take one step at a time. You will try to remember to breathe in and out. At the end, you will try to live for the next day, and the next week, and the next month. And that is what I have done. I am sorry for breaking up, but I have not been asked that question for some years.
Maraming salamat po, Attorney Zamora. I'm sorry for your loss again. That's my only question, Mr. Chairman. Thank you very much, Attorney Zamora. I wish you all the best.
Magandang hapon po.
Magandang hapon po,
Congressman.
Justice.
Sabi nyo kanina, to cope with one step at a time. Hindi ho ba?
Opo.
Baka yung pag-Chief Justice nyo next step yun.
Hindi po. Hindi po ako maasa doon.
Okay. Kung tamang pagdinig ko po kanina, pasensya na lang sa Tagalog ko po kasi galing ako sa norte. Minsan sa amin, sa lugar namin, pinagbabawal magsalita ng Tagalog. Kasi mayroon daw kaming sariling salitan na language dun eh. Sabi nila, taga Ilocos, Slovakia po kami. Kaya sabi, dapat Ilocano lang. Nahihirapan ako minsan sa Tagalog. Anyway, sabi nyo kanina, kung kayo lawyer, dapat kung wala na pag-asa yung kliyente, pagsabihan na natin. Ha? Dapat ganun din lahat ang lawyer. Ano po? Pag ganyan ho mangyayari, baka kakunti na lang may iwan na abogado po. Hindi po ba?
Opo, kaya lang dadating yung panahon na kailangan tayo magtotoo.
Po. Tama po. Ito, seriously speaking po, nanggaling po kayo sa Congress, ilan pong beses kayo nag-serve doon sa Congress po?
Opo.
Ilan po kayo
7 times po.
7 times.
Almost 30 years.
Sa mga iba, sa mga huwes, kami po, with due respect po sa Kongreso, isang causes ng delay po minsan yung mga batas natin ang term nilang ginagamit minsan, antiquated na po. Sinabi ni Justice Carpio kahapon, ang isang cause ng delay itong drugs law Yung sa criminal cases po namin sa lower court, 40% po yan Ang 40% na cases na tumatakbo, pinatagal na tumakbo, ay yung drugs law po Kaya tinatanong ko kay din Amado Valdez kahapon, akala ko yun ang sasabihin niya. Kasi ikaw ay nasa in-interview ngayon, kaya gusto ko pong talakayin sa iyo. Marami po dun sa drugs law na kukulangin po tayo sa oras. Ibabanggit ko na lang po nung iba doon, yung Section 21, alam po nila yan, yung illegal use ng shabu, sinasabi doon kasi sa batas Section 12, sinasabi kasi sa batas in order to be liable for illegal use of dangerous drugs, the person arrested, then he should be found for positive for dangerous drugs after a confirmatory test pag hinuli ng pulis po yan, ipalya sa husgado, premature. Hindi po sabi ng batas dapat positive ka after confirmatory test. Hindi na ho ginagawa ng pulis yan Additional na trabaho Okay. So anong ginagawa ng pulis? Hindi na ho nila papailan yung taong nahuling gumagamit. Biro nakita na nila, hindi pa natin papaniwalaan yung pulis. Sabihin confirmatory test yung pulis hindi na ho dadalhin dyan sa sa chemist yan. Ang confirmatory test, 2 test yan Initial test, then i-confirm. Okay. Pangalawa, pinagdududaan natin kasi mga pulis I think it's time na paniniwalaan natin yung Section 21. Sinasabi ng mga huwes pati ako rin Nagdagdag tayo ng ang haba-habang procedure para ma-maintain lang yung integrity, para malaman, para yung mga pulis hindi nila babawasan. Mahabang proseso yun Yun po, nagdi-delay Wala po kami magagawa. Ganon din sa Sandigan Bayan. Si Justice Hermosissima, tingnan niyo po. Gawa po ng batas ito. 2 jurisdiction ng Sandigan Bayan, yung tinatawag na crimes committed while in the performance of duty or by reason of the performance. Yung pangalawa po sa kabal yun na nakalagay doon, crimes committed in relation to office. Ito nga nangyayari in relation to office po, regardless of penalty. Yung mayor doon sa Mindanao, nakaawal yung empleyado, nasampal niya. Ang kaso doon is like physical injury po Issue na may jurisdiction. Pag ordinaryong tao po, MTC, doon na lang. Ikaw mo yung pagsampal, in relation to office, ang pe-perform, darating po Sandigan Bayan. Pag nagbista po kami, pupunta yung purna witness doon. Manggagaling doon sa Mindanao, magte-testify dyan. Wala pa masahe. Ang sasabihin namin, sige, punta na lang tayo sa Mindanao. Doon tayo mag-trial. Anyway, under the law, pwede naman kami mag-trial doon But that takes place once a year lang Dali na isang taon Gano po yun Marami po Okay. Yung 3019, alam din ni Justice Hermosisiman eh. Pinout ko kay Justice Tess de Castro po eh. Yung 3E. Yung sinasabi ko, hindi lang i-promote, papailan ng 3E. Yung ano ba? Causing undue injury and giving unwarranted benefit eh. Persons eh. Yan, ang daming pinapile po yun eh. Wala pong magagawa ng husgado eh. Ito po ang tanong ko. Meron tayong tinatawag na JELAC, ano po? Yung Joint Executive Legislative. Inumpisahan po yun. Kaya lang po, ang sinasabi nila, medyo delikado po yan eh. Na sumasali ang judiciary eh. Bakit po? Baka sabihin nila, nagkakasabot yung 3 branches of government eh. At saka alam mo, sa Article 8, Section 1, meron kaming judicial review eh. Sa kanila eh. Baka nagkakasabot. So, sabi namin, paano ata namin midain yung problema namin sa legislative, ano po? Hindi ho gaya ng executive, si Presidente, ito ang priority bills ko. Ang judiciary po, hindi namin pwede sabihin, itong gusto po namin, hindi po namin pwedeng sabihin yan eh. O pwede kami mag-participate ba ng diskusyon tungkol sa pagpas ng law? Hindi po namin sasabihin, hindi po pwede yun eh. Bakit po? Kung kami magpa-participate doon, at kami magsasabi doon priority namin, there will be a time kaya questionan nila yung constitutionality ng batas eh. Hindi ho ba? Pupunta yun yung kaso doon. Ipit po kami eh. Ngayon po, sa experience yun, Executive Secretary, di ho ba? Kung naging congressman kayo, ano at na magandang paraan para may daing din namin sa Kongreso, tulungan niyo po kami. Ito po ang kinakailangan namin. Without violating po, yung observation ko na, kung tama po yung observation ko po, mas magaling po kayo sa akin kasi naggaling kayo sa Congress eh. Tayo pinurod lang tayo sa baryo sa Ilocos eh. Ano masasabi? Tama ho ba yung observation ko? Kung tama ho ba, anong mitutulong nyo sa amin kung kayo maging Chief Justice?
Tama po yung observation ninyo na kailangan na meron kayong mga spokesman na kaya iharap yung mga problema ninyo. Hindi lang sa Kongreso, kundi sa executive. Etong mga problema natin, nadaanan na po ng Kongreso yan at nadaanan na po ng executive yan. Hindi lang umaabot din. Ang inaalala ko po, baka naman tayo ay masyadong mahigpit sa ating sarili. Pagdating sa mga panahon na kailangan na iharap ang mga problema natin sa ibang branches of government. Ano po ang pwede natin gawin?
Yung po sanang malaman ko po sa inyo
kung hindi natin ihaharap itong mga problemang ito, we are allowing the problems to fester. Ang nangyayari tuloy, lumalaki, gaya ng sinabi po ninyo. Dahil napaka-stricto ang interpretasyon natin sa batas, anong dapat natin, palitan natin yung batas.
Yun po sana problema po nga, alam mo po, ang katotohanan, nagkikita lang tayo sa Congress eh. Kung budget eh.
Pag-budget.
At ang ginagawa nyo sa amin po, in-interrogate po kami eh. At ginadustify ho ng budget, hindi naman nadaing eh. Buti pa nga ho, one time ako ho ang member ng Budget Committee ng Korte Suprema at mga 2007 marahil. Or member po kayo ng Congress kayo ang minority leader naghintay ko ho kami ng matagal. Doon sa plenary, nandun na kami ng 10 o'clock sabi, wala pa yung minority leader Kaya sabi po ng mga majority, pasensya na lang, Justice, wala pa yung minority leader buti po naman, mga congressmen, mababait po naman. Pinakain po naman kami doon sa lounge, ano po. Dumating po kayo, kasama nyo si Congressman Escudero po. At dumating kayo, iniisip namin, sabi ko, i-blablock yung budget natin. Ni Secretary, Congressman Zamora, naku po, yari na, i-blablock, paano tayo? Mabuti man nung tumayo ko, sinabi nyo, kinakailangan dagdagan. Hindi lang aprubahan, dagdagan ang budget ng Kongreso. Doon lang tayo na nagkikita Hindi po ba?
Opo. Kaya lang po, tingnan po ninyo, maski ngayon pwede po natin gawing isang magandang lunas eh. Ang nag-nominate po sa akin yung majority leader ngayon, si Congressman Neptali Gonzales III. Ano po? Sigurado po sapagkat meron siyang konting taya sa akin, nakikinig po ngayon sa inyo.
Mabuti. Kung nakikinig po, dadagdagan ko pa yung sinabi ko po. Kasi ito po. Para alam po ng buong bayan na po, ito. Talaga ang Korte Suprema, ginagawa lahat ang magagawa para matapos po yan. Tingnan mo ho yung BP22. Ang daming BP22 ito sa Pilipinas. Tambak nun sa RTC. Ginawa ng Korte Suprema para mabilis. Dinala namin sa MTC. Ginawa namin rule and summary procedure. Nagkaroon ng problema ngayon. Paano natin i-expedite? Wala po, nag-plead guilty yan eh. Ayaw makulong eh. Ngunit utang lang po yan eh. Utang lang eh. Ang penalty nun, 1 year or fine. Ang penalty po. So, ang ginawa, kung 1 year, isang cheque, kung isang daan cheque yan, di 100 years yan. Of course, meron man sinatawag sa Article 70 po sa Revised Penal Code, yung threefold penalty rule po. Ibig sabihin, ang tanong dun kung 100 yan na cheque, 100 years ang total na kuwan yan, ang imprisonment yan. Ang tanong dun pwede ba mag-probation yan? Kasi ang probation po, 6 na taon Anong ginawa po ng Korte Suprema? Pwede. Para mapagbigyan silang ng probation. Hindi po depende sa dami ng BP22, kundi yung isang penalty aabot. So, yun ang ginagawa po namin. Gumawa na lang kami po ng paraan. Kaya lang minsan inakausahan kami minsan ng judicial legislation yung penalty din po. Sabi doon imprisonment of 1 year or fine, but not double the amount, but not in excess of 200,000 pesos fine. Pag pinanaan mo ng imprisonment po yan, medyo mabigat. Kung 6 na cheque, as 6, 6 years yan. Anong ginawa ng Supreme Court? Simula ngayon. Pag nag-plead guilty yan, magaling po kayo, pag nag-plead guilty ka sa malum prohibitum po, the BP22, walang mitigating circumstance na ganyan Pag nag-plead guilty yan, anong gagawin natin? Hindi naman bababa yung penalty. Anong gagawin natin? Wag mo nang bigyan ng imprisonment yan, fine na lang para hindi makulong. Ganun ho ang ginagawa namin para mabilis Pag nag-plead guilty, fine na lang. Para mas mabilis po. Marami pong ginagawa ang husgado para
Opo. Tingnan po ninyo ang problema sa batas ng mga korte natin. Kadamihan po ng mga kaso sa iba't ibang levels. Tatatlo lang po yan Number 1, BP22. Bouncing checks lang po yan Pangalawa, drug cases. Pangatlo, appeals of reclusion perpetua cases. Alisin po ninyo lahat yan. O ilipat po ninyo, palagay po ninyo, ilipat po ninyo from the Supreme Court to ilagay po ninyo sa Court of Appeals. Yan po nabawasan 43% ng caseload ng Supreme Court every year. Bakit? 42.9% ng mga kaso ng mga justices. Kayo po, napakarami mga kaso ninyo.
Kaya po, yun po sana tatanungin ko sa iyo Alam niyo maraming kaso, ba gusto niyong pumunta po rito
Tama po yung sinasabi ninyo. Tingnan po ninyo, 42.9% of your cases are really automatic review cases. I-compare po ninyo sa Korte Suprema sa Amerika. For one whole session, 9 justices, ilan ang kaso nila? 100. That is for the entire court. Bawat justice sa Korte Suprema, in some years, 1,000 bawat justice. Nag-average po kayo ng 11,000 to 15,000 a year in a caseload. Hindi ba po? Tingnan po ninyo yung sa lower courts. Etong drug cases. Isama po ninyo yung mga BP22 cases. More than half of your cases are BP22 and drug cases. Hindi ba po dapat yan naiintindihan ng ating legislatura, nalalaman ng ating pulis, nalalaman in short ng executive department, para mag-usap, tingnan kung paano natin makakasiguro na mapipigil natin yung drugs, sapagkat napakalaki pong problema yan. Pangalawa, tingnan po natin kung merong ibang solusyon sa pagsusulat ng mga cheque. Kung hindi po natin gawin yan, this will just keep going on and on and on. And every year, the problem becomes larger.
Opo kung meron tayo sanang oras na pag-usapan po, marami pa po isa na lang po kanina yung isang pong candidate tinanong po ni Torne Cayusa na ang trend po ngayon restorative justice na po pumupunta na tayo doon sa 9344 yung Welfare Act sa mga minors restorative justice na po bakit natin hindi apply sa iba po kasi ganito po ang tanong ko yung probation law magandang batas po kayo atang gumawa nun kasi yung probation law nag-umpisa PD 968 kung PD 968 yan gawa po at ninyo nun hanggang ngayon yun pa rin po ang probation law PD 1990 ang huli ganito ang tanong ko bakit natin hindi natin tignan yung revised penal code po natin marami pong crimes doon na ang penalty po umaabot ng 6 years and 1 day. Sa probation law, hindi po pwedeng 6 years and 1 day Bakit natin hindi reviewin po? At yung mga ibang crimes doon, gawin natin ang maximum penalty 6 years para yung mga tao na gustong ma-reform, mag-apply na ng probation yung part ata ng restorative justice po yan para hindi na pupunta sa Muntinlupa, yung daming pong tao doon
Opo. Kitang-kita po namin yan sapagkat sa San Juan, yung maliit po naming kulungan doon, napakalaki yung problema. Paano? May mga detention prisoners po kayo. Merong mga nag-iintay, hindi lang sa kaso nila, they've already been sentenced, nag-iintay ng lugar sa Muntinlupa. Bakit hindi natin tanggapin na itong mga problemang ito na pag-aralan na nagkaroon na ng karanasan sa ibang mga bayan? For instance, isang pirmin tinatanong sa amin, bakit ba sa mga Islamic countries merong tinatawag na blood money? Sapagkat ang katotohanan, ang mahalaga sa restorative justice is the sense that you are not just out to punish a wrongdoer. You want to restore him to his rightful place in society. You want to restore the peace of the community. You want to restore the community to where it was before it was unsettled by his offense. Hindi ba yun ang dapat natin?
Tama po Dagdagan ko po yung probation na po. Makakatulong pa tayo sa pagtanim ng mga indigenous trees kasi ginagawa po namin sa Husgado. Pag nag-grant po ng probation, ang ginagawa po namin kondisyon yung 2 years ng probation mo, magtanim ka ng 10 punong nara, magtanim ka ng mulabe, dyan sa watershed ng Balara. Hindi po makakatulong din tayo sa environment kung i-expand natin ng coverage po ng probation.
Tama po yun, Justice. Tingnan po ninyong ginagawa sa Amerika. Lahat ng highways na nakikita po ninyo, hindi ba nakikita po ninyo, may nagtatabas ng damo doon, may nagpapala, may ano po yun? That is community service which is exactly what you mean by restorative justice, di ba po?
Kaya po. On that note po, yun na lang po ang tanong ko. Maraming salamat.
Maraming salamat po.
Thank you po.
Salamat po.
Okay, there is no more candidate for interview this morning. We will resume at 2:15. So, the session is suspended.
Salamat po sa inyo.
Dito na lang po tayo. Hello? Justice, magpapapicture po tayo.
Yes, sir. Break.
Kundi yung isang penalty, aabot. So, yan ang ginagawa po namin. Gumawa na lang kami po ng paraan. Kaya lang minsan inakausahan kami minsan ng judicial legislation yung penalty din po, sabi doon imprisonment of 1 year or fine, but not and double the amount, but not in excess of 200,000 pesos fine. Pag pinina